Someone make it make sense.
Probably a couple.
Hello, everybody, and welcome on in to our Karen Reed live stream here, the retrial. Week 1 is in the books, and yeah, so we have a lot we're going to talk about today. But first, we are going to start with a little trip down memory lane, if you will, from day 2 of the first trial with Tim Nuttall on the stand, and of course we have the Lolly Bird and some classic testimony here, just to remind everybody what it was like last time.
With the same setup as Ambulance 1. Both those stations also have ladders that run out of them, ladder 1 and ladder 2 respectively, and the crews from Ambulance 1 or Ambulance 2 will cross-span those ladders as needed.
Now, with respect, if I could turn your attention to January 28th into January 29th, so Friday into a Saturday. Do you recall 2020? Recall those days? Did you work one of those 2 days?
I was scheduled to work the morning of the 29th, I believe.
You were scheduled to work essentially the morning, 8 a.m. on the 29th until 8 a.m. on the 30th. And prior to, or the 28th, sort of going into the 29th, what, if anything, were you aware of as far as weather that had been forecasted or that was reportedly coming?
I was aware that there was a significant storm, supposedly. Well, there was a significant storm coming through. I woke up very early that morning just to check. I took a peek outside at my house. I live in the city of Brockton. I noticed that the conditions it was starting to snow a little bit. So I got up early and got ready for work and left earlier than I normally do.
And about what time, which station were you assigned on that?
I was at Station 1, 99 Revere Street, and I was on Ambulance 1 for the day.
And about what time did you arrive at Station 1?
Due to the inclement weather, I believe I arrived.
You guys know where this is going? Does anybody remember where this is going?
Several hours early. I showed up to the station around 5:45, 5:50 that morning.
Several hours early? Man, I understand being early for work because of the weather, but like several hours early.
And around the time that you were driving from your home to Station 1 in Canton, what, if anything, did you note as far as sort of driving conditions, visibility, anything else?
The snow was starting to accumulate. The roads, I drove through several towns, but the roads were starting to be treated, but they weren't pristine. There was obviously a buildup of snow starting on my ride, which was part of the reason I left early, just either to relieve people if they needed to get out before the storm really hit, or just to help them with snow removal.
And to that point, when it comes to sort of snow removal at the fire station, what, if any, sort of duties and responsibilities do yourself and the other firefighters have to in relation to snow removal around the station?
So we're responsible around the station to keep what we refer to as the apron clear of snow. The apron is where we back our fire trucks into and out of the station. So we remove all that ourselves. We have a plow truck. However, we'll also shovel walkways and stuff for the public if they need to get in. So that was one of the primary. The crew was actually outside removing snow when I pulled in to the station that morning.
And it may be pretty self-explanatory, but as far as the apron itself, why is it so necessary that the apron remain clear as far as snow is concerned?
It might be self-explanatory, but let me ask anyway. And let's talk for hours painstakingly about the shoveling of the apron.
To maintain a path for the apron.
And we should also keep in mind, the apron's not been mentioned once in this retrial.
Emergency apparatus to get in and out in a timely manner.
Now,
oh boy.
Beyond sort of the snow accumulation that you noted on your way to work that day, what, if anything else, did you note as far as the weather conditions, whether it be temperature, winds, anything to that?
Oh my God.
They were approaching blizzard conditions. It was windy. Wow. It was still very early in the morning, so it was quite dark, and it was windy and snowy. So we were approaching blizzard conditions, like I said.
And when you arrived there, did a call come into your station sometime around or shortly after 6 o'clock in the morning on the 29th?
Yeah, I arrived, as I previously stated, around 5:50. I had put my gear, my firefighting structural gear, out with Ambulance 1, just in the event that there was an emergency. And as I was doing that,
I love that even he is like saying, as I just said, again, I said, like, because literally he's just asked the same things over and over again.
The emergency tones went off for a medical.
If you recall, what was the report in regard to, what was the dispatch in regard to as far as the medical was concerned?
The overhead dispatch came in as a unresponsive male in a snowbank at 34 Fairview Road outside. Unclear any further information. So when that came on, we had one of the paramedics that morning and one of the firefighters who was a relatively new firefighter. I made the decision to step onto the ambulance to provide an extra set of hands as one of the more senior paramedics in the station at the time.
And correct me if I'm wrong, when you step onto the ambulance, you're essentially still sort of getting your gear on and getting dressed, right?
Correct. I was, as the tones were going off, and because I came in so early, I was still in civilian clothing. I had a Canton Fire t-shirt on. So I actually donned my turnout gear for that call.
And as far as the other individuals on that ambulance one that were going to that call as well, who were they?
So it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly.
And Mr. Kelly, he was sort of the less experienced one at that time, is that correct?
Correct.
So you get into the back of the ambulance and start going to the scene. Now, as far as other sort of vehicles or apparatus, who, if anyone, or what, if any other sort of vehicles were dispatched on this call?
You'll know where else
The initial dispatch was Canton Engine 3 and Canton Ambulance 1. Through the severity of the call, depending on how it comes in, the shift commander, which is Car 5, he will usually respond to any significant incident. So he also added himself to the call, just as a senior officer with us. So the final dispatch, I believe, was Car 5, Engine 3, and Ambulance 1.
You know who was on Engine 3 and who was in Car
5? Car 5 was Captain Robery. Engine 3 was Lieutenant Greg Woodbury, firefighter Frank Walsh, and firefighter Katie McLaughlin.
As far as the Ambulance 1 that you were in, obviously there's somebody driving and there's somebody in the front passenger seat, correct?
Correct.
Okay, so who was driving and who was in the front passenger seat?
I don't want to speak out of turn. I honestly can't tell you who was driving. I was in the back. I was in the back patient compartment of the ambulance. Just because there's only 2 seats up front, so I hopped in the back.
Thanks, Franks.
And so when you're in the back of the ambulance and you're going to the call, what is it that you're doing in sort of preparation for arrival?
So as I previously stated, I was I came in early, so I was donning my turnout gear. I had my boots and structural firefighting pants
As I previously stated, Gazella, dude, it's great.
on. So I finished putting those on, and I put the rest of my gear in the back. And as we were driving to the scene of the incident, I started prepping the gear that we were going to need off the initial dispatch and unresponsive mail in the snow. So I grabbed our first in bag, which has miscellaneous medical supplies, some IV supplies, and interosseous drill kit, the airway bag, which has just a bottle of oxygen, and then quite a bit of airway management supplies and our cardiac monitor. So I had all of those prepped out and ready to go. So as soon as the ambulance was in park, we could step right out, ascertain what we had, and go from there. So when the ambulance arrived on scene, I had all 3 of those bags on my person, and we were able to, the entire ambulance crew was able to step out and provide patient care.
And as far as, if you know, approximately how much time elapsed between the time that you hear sort of the sound go off and you get in the ambulance to the time that you
None of this
arrive
matters.
on scene on Fairview?
I couldn't give you an accurate estimation of the time. Like I said, I was in the back. I was trying to prep everything and get myself kind of prepped just in terms of appropriate attire. So I couldn't give you a fair estimate.
As far as when you arrive on scene, you step out of the back of the ambulance, is that correct?
Yes.
And as far as the weather conditions where you were on Fairview, what, if any, difference was there between the weather conditions there versus the weather conditions when you were arriving at the station?
You guys, it's like, honestly, it's like it's become a meme. Like this trial, the first trial with Wally, so many things that he said were obviously became a meme. But it's like, I haven't gone back and listened to this since it happened. And it's like even worse than I remember. Like, again, with the weather conditions, mind you, we didn't start at the very beginning of the testimony. I skipped ahead to where it got to the day in question. And prior to that, he was asked the same questions about the weather already bazillion times. It's crazy.
I remember, as I previously stated, I remember it was
There it is again, as I previously stated.
still very dark. The sun was not up yet. I remember the wind. It was quite windy that morning. The wind had, in my opinion, had seemed to have picked up since my drive
Because was it approaching blizzard conditions?
in, and the snow was increased.
Great.
And so when you step out of the ambulance, can you describe to the jury sort of where you go and sort of what is it that you first see when you get out there?
So I stepped out of the ambulance and came around with all 3 bags. I could hear commotion. I could hear some screaming off in the distance. I couldn't really tell you where it was coming from because it was still quite dark. Came around the passenger side of the ambulance, walked in front of the ambulance. And there was a small huddle of 3 individuals.
So actually, James, that is the perfect comment to segue us into the next thing we're going to do. James says, going back is definitely crazy. So much we missed. Yes. Great point. Needs and Z's, have I read Aidan's new court filing? Do you mean there's a couple. Are you talking about the one about the agent for the state or whatever, or the Commonwealth? Or are you talking about intervener with the sequestration order? I've seen all of them, so which I don't know which one you're referencing specifically, unless there's another new one. But let me know. So yes, okay. So now what we're going to do now, as you guys, how many times do y'all hear? And you're probably sick of hearing it. As I will say, when I go back and do timestamps, I always catch something that I've missed. Right? Speaking of going back, and sure enough, yes. So since day 3, I was still getting caught up on timestamps, and in going back and doing timestamps, I noticed some things from day 1, the hearing at the end of the day, that I had, oh my God, sorry, that I had missed. Am I messing with you? What do you mean, Twiz? That I had missed. And I don't know, I think other people may have missed it. I didn't, and anyway, things that I think were missed that I wanted to go through and point out, because there's some interesting things in here. So, this day, right, was so much to take in. So there was a lot, and this was at the very end. But anywho, so we're going to watch this again. It's not long, but we're going to watch this because there's some interesting things in here. And honestly, as we go through it again, we'll probably notice even more new things. So, I don't know what Twiz is saying about messing. I don't really mess with. I'm not really a messer, as it were. Yes, I did. The Christie, yes, or whatever it is. Yeah, I did see that. Yes, Krusty, right? Got it. Yes. Okay, so let's take a look here. So again, this is day 1. This is the hearing at the end of the day. At the end of the day, hold on. Twiz, why do you say I'm messing with you? Where'd she go? Here she is. Okay.
The motion for compliance, our position is the defense did not comply with the order. This is an ongoing issue which relates directly to the credibility of potential ARCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Lenschler. That does not reconcile with the past positions and representations of the defense to this court, to the court.
I'm pausing real quick. So Neeson's okay, because she's surprised that I wasn't more incensed. But the thing is, one can only be incensed so much before one implodes, right? Those of you guys who were there when we went over on the last BK stream and reading there was the motion to strike the death penalty, and then there was the vague and undisclosed witness testimony. Just about broke me. Like, I was broken by the end. Those of you guys who were there, I was like, no longer a human. So, yeah. But also on just a more practical level, again, I'm just one person. And so while I'm privy to what's going on with Turtle Boy, I've not, there's some people who've been covering everything pertaining to his case and related to him. And I've not really covered that unless it's like directly related to Kearney, like in her, like, for example, when they had the joint hearings and whatnot. Right. So, I suppose it makes more sense. I'm really, what is what I'm trying to say? I'm really thorough in the sense that if I'm going to cover something, I cover like everything about that thing. So, I guess it makes less sense for me to, I can totally, if you guys want to read it, we totally can. We can totally read it. That's totally cool. I guess I just feel like, well, if I'm going to read that, we need to go back to the beginning and start from scratch. You know what I mean? That's just the kind of how I am. It's my own personal thing. But we can totally cover it just as it is. And if you guys want to, yeah, major corruption claims. Oh, I know. Oh, I totally know. I'm aware. I'm aware. I mean, yeah. Same thing that's being documented. Let me see what Rollo said here. Right. but we can totally read it. Let me know if you want to go through that and we can. So, okay. But first, before that, guys, there's something really, really important that we're about to hear from this hearing. So let's keep listening.
Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCA mainline, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Rentschler. I find it difficult to accept that these were all for scheduling purposes. We also had your honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed, and we have received nothing. This is important because if we look at the first half of ARCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that ARCA should be ordered and required to provide that evidence as well, so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of ARCA testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
Take it more quickly. The second motion.
There's 3 main things that I noticed doing timestamps that I missed the first time around. So we're going to get to those here.
Motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations. And as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with ARCA. They could have called any expert, asked for any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden
I know.
of their decisions. We will not have the ability to rush through, have Dr. Rentschler come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him.
Inadequate.
It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline. That's technical, but the reality is we're all trial lawyers. We've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new, we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
Okay.
I mean,
So
yeah.
this issue, I'm going to ask you to be as
Okay.
brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity. So I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate 2 categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders. And I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so
You're ready, guys.
texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear, they would be provided. And he said no. And I asked you at sidebar whether they were deleted. And you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
Guys, 2 years old. Y'all, think about this. What is the problem here? What is the problem here? What is the problem here? 2 years old. Do the math. Tell you what, Twiz. 2 years old. When did the defense, to our knowledge, first learn about ARCA? You guys, what? What? This blew my mind when I was doing timestamp. I don't even know if I don't know if I timestamped it or not, but when I was doing the time, this blew my mind. Welcome, Turquoise Kitten. I don't know. Do you guys see the problem with this? Let me play this again.
Why don't you explain that?
Well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They
Ding, ding, ding. Franks gets the million squirrel points. Yep. They learned about ARCA like during the trial last summer. So I'm surprised that I'm surprised nobody said anything. Like it wasn't just me that missed it. Nobody said anything. Like, what? Hold on.
No idea what that means,
This is
Mr. Leslie.
crazy.
Why don't you explain that?
well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, aren't the ABA
So what
guidelines?
happened when we watched this before? So she asked this question about the ABA guidelines. And then, we had a lot of discussion about this. I'm sure other people did as well, because that's what it seems like the thing is. So what happens is he says this thing about the text messages being 2 years old, but she doesn't catch that. She's more concerned with keeping them or not and not hearing about the time period. So her follow-up is about the ABA guidelines. So this 2 years thing totally didn't get, like, what?
The counsel is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware
In
of
regard
that.
to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, there's 100 text messages leading up to trial when I was told that by you that there was a pause email and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Leslie.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided pursuant to every order, every single text message that exists.
The thing is this, I don't remember. It might even be worth going back to last year when ARCA comes in. The way it came out at trial, my recollection is like they had heard of them, but had never communicated with them. That's my recollection of it from last year. And that, we've gone back and watched the voir dire so many times, but we've always gone back and watched it for different purposes, right? And so this would be a new thing to go back and listen for if we want to do that. But my recollection is that they literally just found out about them and had only just communicated with them once the trial had started, type of thing. So I don't know. This just seemed crazy to me. And it sounds like it was 100 text messages though they said prior to trial, the first trial. So that's a lot. But there's more.
Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarized all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCA, we turned over her texts and the text of her text messages.
This is another thing that I caught, as I was doing timestamps. So the whole thing, right, that they're not required to save the content of the text messages, they're auto-deleted, But if that's the case, then how and why did you turn over the content, as in the text of the text messages, from Miss Little? Listen.
Completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCA, we turned over her texts and the text of her text messages. There is nothing else in existence.
So that's just another thing where it's like, well, and I'm looking at this from the standpoint of the Commonwealth and Judge Bev are going to find any reason they can to stop ARCA from testifying or to limit that testimony, right? I'm not saying there's anything nefarious going on, but you know who's going to say that is the powers that be, Judge Bev. And so I'm scrutinizing it because that's, we all have seen it. Even when there isn't anything that seems like it could go wrong, somehow it seems like she finds something. She'll make it up if she has to. So, okay, there's another
To
thing.
provide, and importantly, the defense was under no order to preserve the text of text messages.
Okay, right. But yet, why did you preserve the text of the text messages from Miss Little then? See what I mean?
And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything we can that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have. And in addition to that, we created a document so that it would be easier. We're the one who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect because we turned over, and we did it recently and consistently. We've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024. And there's no order that required those to be preserved. And there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second.
Thank you, Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCA is underway, working on, that we...
So hang on. So Needs and Z's says, because Liza and Alan were the only two people communicating with them, no one else was. I'm not sure what that's in response to, but what I still don't understand is why, if they're not required to save the content of text messages, and if there's an auto delete situation, why then do they have all the content of the text messages between ARCA and Miss Little? Like he said, we didn't only just turn those texts over, we turned over the text of the text messages. So why those and not, you see what I mean? It's like, if the argument is like, well, they auto delete and we're not required to save them as per the order, then why did you save some and turn them over? I don't know.
We will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quick.
I mean, the audio, fine. That's fine. I think you're missing what I'm saying here. And he's like, fine. My point is, I feel like I've already said it a bunch of times. I guess James sees what I'm saying. Like, if you're not required to keep it and it auto deletes, then why do you have some and not all, right?
Quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely...
Okay, because it's been 2 years, but they said the auto delete is after 30 days. So the text messages from Miss Little would still be past the 30-day mark. And of course we could, but it doesn't, remember, y'all, what we think doesn't matter. This is going to be assessed through the lens of Judge Bev, right? Like I said, you don't even need to give her a reason to be biased against the defense, right? So if I'm seeing things that she can pick on, you see why I'm pointing this out? You see why I'm pointing this out? She's going to do everything she can, and so is the Commonwealth, to keep them from testifying. So, of course, it's not fair. Of course, it's hypocritical. Of course, it's biased. Of course, it don't. But what we think doesn't matter, right? Unfortunately. So she could have had, so that does a great point, Dr. Rob, and that could get her on the auto delete function. However, the fact still remains, if you're not required to keep them and turn them over, why did you turn them over? You know what I mean?
Discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form.
Welcome, Kane.
Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file.
You could be right about that.
In February of 2000 or February
You
19th,
could be right about
we
that.
finally get the raw images from Aperture in the scans. That's the first time we get raw images in scans. You can't have an expert work on anything until you even get those raw images in scans. We move and we have a hearing on March 20, 2025 to preclude Dr. Welcher because the slides are so incoherent in the
So the actual next thing I wanted to get to is actually, I think it's when Breenan comes back up. So let me just go ahead a little bit. Like I said, there were 3 things that I noticed that I didn't catch the first time. So, and then the thing that I'm going to reference here is, you know how Breenan has been saying all this time, I just know there's more. I just know there's more. And what has he also been really hyper fixated on, right? He's been hyper fixated on these interviews with Karen, right? So hyper fixated on them, the interviews, the campaigning, right? Okay.
ARCA. We moved expeditiously to do that. We got the permission from the government.
100%.
And as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCA out because of the inframer fence. That's
Okay.
right, but not next week. So I really need to get her, show her court scheduling on this topic. Fence from putting.
Wrap it up.
There are no order. The statement I'm making.
Thank you.
Okay.
All right. So as you all know, I previously wanted to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found, and I believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations.
Pause me real quick. Go ahead. I think it's coming right up. Could be. Let me just see here. Okay.
How long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now because I got to talk to ARCA and I got to understand what they have and what they don't have. So I think, in fairness, I think it can take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order, hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right. Thank you.
Oh, well, okay. So, okay. The thing that I was going to say must have been the next day when they talk about this again. So I'll just tell you guys what it was. So the thing number 3 that I noticed during times, thing number 3 was when this comes up again, Breenan references, you know how he had said, like, I'm not Nostradamus and I know there's more, and it's like, where is he getting this from? Right. And who knows what, I'm not saying it's true. Right. But the thing that I think is interesting is where he says he gets this from. So he references, again, I think it's probably the next day, he references that where he thinks there's more text messages or whatever is based on, guess what? One of those interviews, one of Karen Reed's interviews, and it's probably one of those ones where they're talking. Remember how he wanted the, where they're going off the record and whatnot? That would be my guess. The way he says it, that was my impression from the way he describes it. I was like, oh my God, his obsession with these interviews, right? I feel like he goes home and just watches these doing like the evil villain type of laugh, right? That's what I picture. He just goes home and watches these interviews over and over and over and over again and obsesses over them. That's literally what that's what I picture with him. Like, I'm going to get you, like that's what I picture. And like, every time he watches them, he like is thinking of something else where he can, use it in some fashion because he doesn't have a case. Right. So that was the third thing, is that, just going to his whole obsession with Karen on these interviews. I mean, he really is obsessed, and beyond even just Karen and her statements, it's now even as it pertains to communications with ARCA. So there you go. Exactly. He's hyper-focused on ARCA because they can crumble his entire case. Yep. And the interviews, he can use it directly against Kearney. And that's the thing. Like I know this comment came in before I just said what I said, but what's funny is the third thing I was mentioning is like the combo of both, right? Where it's like her interviews and Karen, but then also ARCA, and it combines the two. Like where I guess there must be some point where they're talking about ARCA on one of those interviews about their communications, and he's like, I gotcha, you know? So he pays, who pays Karen to do what now? And I don't know what you're referencing here, Rolo. How do you reverse what now? Are you talking about Kane's username, maybe? I don't know. Okay, so now we are going to pop on over to day 3. Day 4, rather. Sorry. Day 4. Okay. Let's see here. Why is it not going full screen? That's stupid. That's weird. Hang on. Okay, let me just try this again. Why are you not going full screen? That is very weird. Let me try it again. Okay, now we got it going full screen. That's so funny. YouTube is so funny sometimes. Okay. All right, cool. What's going to happen here is they're going to be talking to the jury about the jury view. This is actually very interesting. I mean, I feel like I've actually not heard this done before where they, I mean, that I can recall anyway, where they give like a little speech about what they want the jury to pay attention to. Okay.
Hear ye. All persons having anything to do before the Honorable Beverly
Welcome, Scott Middleton.
Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
For the record, before the court is Commonwealth versus
I mean,
Kearney.
it's so true. And I brought that up the first time we listened to the hearing. I was like, yeah, that was a good point made by Leslie that they don't have to turn it over. But as we all know, it doesn't matter. It's not about being fair, right? Unfortunately, like the thing is Judge Bev is not concerned about any discovery violations. She's not concerned about credibility. She's not concerned about candor when it comes to any of the Commonwealth experts, right? But she is when it pertains to ARCA. So it's a double standard, and it's just awful. I hate it.
Read 22 CR 117. The parties are present. Our 18 jurors are present. The matter is on for trial.
Thank you very much, Madam Clerk. Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. When we leave you out there, we're very much aware that we're leaving you in another room waiting, but we were working this morning to help streamline things, and we were successful, so we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone nodded
Agree.
affirmatively or said yes. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did any of you happen to see, hear, or read anything about this case since we left yesterday?
No.
Thank you. Everyone said no. All right, folks, as you know, this morning we are going on a view. And a view is simply, we're going to a place that you've heard about and that you will continue to hear about during the course of the trial. The purpose of the view is to help you better understand the evidence, which you'll hear during the course of the trial, and to help you appreciate the location and its surroundings.
The timing of this is very interesting, right? When we get to the end of the day, we're going to recap the week and talk about what did the Commonwealth prove, if anything, what if anything. And we're gonna reference the verdict forms and the jury instructions. We're gonna look at the elements of the charges and see if you're and try to be objective, right? If you're on this and think if you're on this jury, what are your key takeaways? And do you feel, and if you're on this jury, right, has the Commonwealth met any of these elements of the charges? Okay, but also putting that into context with this view, right? That it's very early in the case to go on the view. Was this the right call? We'll talk about it.
So the view that we're going on is part of the case, and it means that the observations that you make there can be used and considered by you in your deliberations on this case in reaching a verdict. So we're going to, you've heard 34 Fairview Road in Canton. The lawyers and I will accompany you. For the Commonwealth, we'll be accompanied by Attorney Brennan, and ADA Lally, ADA Schillinger, and for the defense, Attorney Yannetti and Attorney Little. The lawyers will have the opportunity, Mr. Yannetti and Mr. Brennan, have the opportunity to point out various things that they may want you to direct your attention to. Otherwise, there's no conversation between the lawyers and the jurors. So it's simply in a few minutes, you'll hear a little bit from each Mr. Brennan and Mr. Yannetti about what they want you to look at. And then when we get there, they'll direct you, look in this direction. They won't be able to testify to you, but they'll direct you on what they want you to look at. While you're in the view, you're not to take any notes. You're not to take any pictures. You're not to conduct any independent investigation at all during the view or any time during the trial. You're not to return to the scene or ask anybody to go back there for you. Today's your chance. You'll see photographs during the course of the trial, I bet, but today's your chance to really look at everything. So the best way to summarize a view is that your job is to simply stop and look. It's really no more complicated than that. So your responsibility is to see the place, observe it carefully, and to remember what you see. Now, during the trip to and from the view, and while at the view, you're not to discuss this case or anything about it with other jurors. We'll be accompanied by court officers who will direct you, and the court officers are there for all of us. So you'll be under their supervision until you're returned back here. So that's basically it. We'll be leaving in a few minutes, but first, before Madam Clerk swears the court officers in, Mr. Brennan, do you want to make a view?
Okay, here we go. View open.
Yeah.
Please.
Thank you, Your Honor.
I've never heard
Good
this done
morning, ladies and
before.
gentlemen. As Her Honor explained to you, we're going to go to 34 Fairview Road. We have some exhibits that are already in evidence. You haven't had a long time to look at them, study them. But essentially, we're going to go to 34 Fairview Road. I ask you to pay attention to the street, the front yard of the home.
Let me back this up a second. He says, hold on.
Road. We have some exhibits that are already in evidence. You haven't had a long time to look at them, study them.
All right, you have some exhibits that are already in evidence, he says. And then he says, you haven't had a long time to look at them and study them. So when I ask the question, is this the right time for the view? Well, his words right there go to that, right? Because it's like, well, if they've barely had time, I mean, yeah, there's very few photos of the house that have come in, right? At this point, the jury, it's true, the jury really hasn't seen much of the property. So if they're really not even that familiar with pictures and the landmarks of the yard and whatnot, is this the right time for the view, right?
Fairview Road. We have some exhibits that are already in evidence. You haven't had a long time to look at them, study them. But essentially, we're going to go to 34 Fairview Road. I ask you to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different vantage points. Take a look from that area where the flagpole is, from where the fire hydrant is. And you'll see on the street before the grass is a little more concrete that comes up a little bit. I'd ask you just to
No, there's really not. Though.
One thing I'd suggest is...
And let me ask you this. So Dr. Bob, if you're still listening, Dr. Bob has been there, okay? This was a big thing in the first trial, right? Is there a curb? Is there not a curb? There's like talk of, anyway, it doesn't look like there's a curb to me, but he just says there's a little burn.
From where the fire hydrant is. And you'll see on the street before the grass is a little more concrete that comes up a little bit. I'd ask you just to note that as you go there.
If Dr. Bob is still listening, let me know if you saw a concrete that comes up a little bit. They moved the car up on this view. Thank you for that as well. And I agree they should be allowed to take notes, but even if they're allowed to take notes, I still feel like this probably would have been more beneficial later on in the trial. But also, let me just pull this up here. The DUI charges are all connected to either murder or leaving the scene of an accident, except for right there. It is. I wish it were that simple. Is there a DUI charge alone? You mean that doesn't involve a collision? No. The thing that would involve no collision would be leaving the scene. But again, it's not simple. And we will take a look at it. We'll take a look at it. It's a lot, and it's really doesn't follow any type of like it's not intuitive. It doesn't follow logically the way that the charges are laid out. Even with like the lesser included, it's very convoluted. It's extremely convoluted. So we will pull up all of that. I was thinking we would probably do that when we get to the end of the testimony for this day, as we go through and assess the week as a whole. But yeah, so stick around, and if you want to go through, because it's really, really important, right? These are great questions, right? Like, if they find her guilty of drunk driving, can they just go that route, right? Like these are all great questions, and there's just a lot of different elements to the different charges, and you know, to what extent, you know, the collision and the nature of the collision, and it's just, there's a lot. So, welcome official. And James would know there's no concrete in a curb. James would know. First, couldn't agree more. They make no sense. It does not need to be that convoluted. 100%. It is ridiculous. We've all watched a lot of trials. I mean, take for example, Kowalski v. J. Hatch. In that case, the charges, okay, and how that whole thing was laid out was way more complicated. Anyone that followed that trial will know exactly what I mean. However, the way it was explained made it easy to follow for a jury. Same for Duff v. Heard. Duff v. Heard wasn't nearly as complicated as Kowalski v. J. Hatch, but yeah, it's just so convoluted for this case. It's wild to me. They could make it it could be simple. It should be simple. Can we go over Aidan's filings? Do you mean first before we get into the testimony? Yeah, that was a great trial. Loved that trial. Let's continue to listen to the jury view statements because it's short and we're already on that topic, and then we'll see if you guys want to do Aidan before we get into the rest of the testimony.
One thing I'd suggest is April 25th, 2025.
Oh, before jury instruction. Gotcha. Yes. Gotcha. Roger that. Yep. That'll be perfect. That's a great plan. That's a great plan. Yeah. We'll do it that way. So we'll continue on with the day. It's not a lot of testimony, right? We'll continue on with the day, and then we will do the Aidan, Kearney, Turtle Boy, and then we'll do the jury instructions and verdict forms. Sounds like a good plan.
So the weather will be very different. The temperature will be different. The conditions.
Obviously, paint.
We're going to go there probably at 10 o'clock. It won't be the same visibility. It won't be the same elements and the same colors. Keep that in mind when you're looking around. When you look at the Lexus, a couple things that actually you look at, there is some evidence already in photographs of the right rear tail light. When you look at that tail light, it will be different in the photograph than as evidence. It has been removed, so it will appear differently, and you'll later get testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height of the right rear tail light.
Make note.
I'd also ask you to take note of.
Make note, but like you can't take notes. And the height, like what are they can't measure it anyway.
On the top of the hatchback, there's a part that protrudes. I'd ask you to look at that. Thank you very much.
This is crazy.
Thank you, Mr.
I've
Bennett.
never heard of this before with views where they tell them to look at certain things.
Gianetti?
Thank you, Ron.
Thank you, Dr. Bob.
Good morning.
Dr. Bob is just the best. We love Dr. Bob so much. Also, please send all of your thoughts, your Rainbow Bridge thoughts to Bandit, who we love, and he's crossed over. I'm gonna cry just thinking about it. It's just, we love you, Bandit. Oh my God. The curb runs from the mailbox all the way up in front. Interestingly, there's a cutout near the mailbox where the curb has been repaired or replaced. Look at that. Look at Bandit, you guys. No, don't ever be sorry. No, not at all. I'm happy to cover everything you guys want. Y'all know I'm nothing if not thorough, and I'm always gonna. You don't have to ask me twice to do more, right? You don't have to ask me twice to do more. I'm happy to do it. So I think that's a good plan though, as far as the order of events. So yeah, appreciate this input though from Dr. Bob here.
As I told you at the start of the trial, my name is Aidan. I have an office in Boston and in Denver. And on behalf of my co-counsel, we will be accompanying you on the view that you will take today. Although the view is not evidence, I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this courtroom. You've already received in evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are the best computer that you could bring to the view. When we get to 34 Fairview, we will be pointing out certain things that we'd like you to observe. The house, the second floor window to that house, the 3 front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole. And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn.
Okay.
The distance between the front doors to the house and that front lawn. The distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus. Just stand next to it. Just size it up. Take it in. You were all selected as jurors because the parties entrusted that you would do a proper investigation of this case within this courtroom. On behalf of the we have every confidence that you will do a proper investigation. Thank you.
I really
All
like
right,
this.
jurors, I have to make something very clear.
Y'all know I'm a huge fan of Mr. United.
So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look. Okay.
I just feel like they've made this way more complicated. It's like you're only just there to stop and look. Just stop and look. But then they give these speeches. Take note, and Hank Brennan, right? Take note of this. Take note of that. Da, da, da. And then, and it's like, if I were on this jury, I would be like, why are we making this so complicated? Are like, what? You guys see what I'm saying? It's just, this is all very odd. I've never, in any trial where they have a jury view, I've never seen such a preamble. Usually it's like, we're going on a view, let's go. And then we all know that they can't talk to anybody. And they go and nobody talks and they stand there in silence and they walk around, they look at the things and then they come back. This is very, I don't know.
In reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look. Okay? Those are the instructions. We will see you in a few minutes. All right? Thank you. Oh, sorry. Madam Clerk has to swear in the court officers.
You can all raise your right hand, please.
She goes in street clothes?
Do each of you solemnly swear that you will take the jury upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary? That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out some places or things.
Oh, hang on. Right. That's right. I knew there was one other thing. Hold on. Okay.
Hand, please. Do each of you solemnly swear that you will take the jury upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary? That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues.
What? Did you guys hear that? Did you guys hear that? The attorneys are allowed to speak to the jurors at the view and point things out. Listen, blows my mind, exploded.
Jury
What?
upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary. That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such
So how
places,
this normally goes is this, guys. How this normally goes is this.
nor any person to speak to them unless it be the
Nor permit any person to speak to them. That's the end of that sentence. Every jury view. No one is to speak. Like, you guys, all of y'all who followed Murdoch know what happened with Becky Hill, right? And that wasn't even speaking to the jurors. That was just like possibly exchanging glances on the bus. They're not supposed to speak to what? I cannot believe this. Every jury view, that's the rules. The rules are literally, you're just there to witness. Like, the whole point that the attorneys go is just to witness that there's no fuckery, that the jurors are not talking to each other, and that no one else is talking to the jurors. That's the point. What? I cannot. I can't. Y'all. What?
the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues. That you'll keep the jury together until they shall return to court, unless the court shall otherwise order, so help you God. Thank you.
Unbelievable.
All right, thank you.
All right, please. Follow me.
Unbelievable. Unbelievable.
Goodbye.
Unbelievable. Goodbye. I love how it says goodbye as if everything's normal.
Goodbye.
No, it's not normal. It's not okay. I'm not okay. Okay. So great. Now, last year we got to see the jury view, like, you know, but I have not seen that come out yet. I don't know what the dealio is with that. I've looked for it and I've not found it. But last year they did a release footage and we watched it, of course, of the jury view. But anyway, all right, here we go.
Court is back in session. You may be seated.
Who is your next witness?
Your Honor, Commonwealth call Dr. Garrey Fowler to the stand.
Thank you.
And I will be honest, who all got PTSD when you saw this dude's face after the last trial? Who all got who was like, oh God.
When you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Sure.
Good morning, doctor.
Good morning. Good morning. Good morning.
All right,
I'm
Mr.
pausing
Allen.
it real quick because it has scheduling update. It says retrial. Half day on Friday, some testimony and jury view. Monday, half day for testimony, half day for voir dire, ARCA. Oh boy.
Whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Monday, guys. That's what
My
Monday.
name is Dr. Garrey Fowler, Epperson Frank, A-L-L-E-R.
And what is
Says yes, we get to watch ARCA voir dire. That is going to be insane. I'm going to cover that live. I know some of you guys have said you like it when I do it at the end of the day. I'll probably do both. I'm not going to be able to not be watching that live. So I probably won't even be able to sleep. Not that I really sleep anyway. I'm like already now, I'm like, oh my God, Monday. Like there's testimony and then ARCA that we will get to watch that. That's going to be insanity. And I'm going to cover that live. And if you guys are here, great. And if you're, then we'll probably do it again in the evening. Again, as James all says, and I all say, it's always worth going through things more than once. It just really is. Yeah. I'm like already getting like really dude. I'm on like pins and needles already for this whole thing with ARCA because this is going to be, whatever happens, it's going to be insane. And we never know what to expect with this. But yeah, so this Dr. Fowler, this is like, this was painstaking. This was painstaking last time. But guess who's back? Guess who's back, guys?
What is your occupation?
I am a physician pathologist.
And where you work?
I work currently at Signature Healthcare in Brockton.
And how long have you worked at Signature and in what capacity, sir?
Signature, I started, it's probably 6 months. I took a new job 6 months ago. I am the chief of pathology and the laboratory medical director at Signature.
And where did you work prior to your work at Signature about 6 months ago?
Prior to that, I was at Good Samaritan Medical Center in the same capacity.
And how long did you work at Good Samaritan for?
Since 2015,
We're going to put it on 1.5.
late 2015.
And did you work in any
Might be able to even bump it up from there.
capacity similar to that prior to working at Good Samaritan?
I
Prior to Good
understand.
Samaritan, I worked at the Kearney Hospital, which is in Dorchester. Started that job in 1996. So I
Nothing like starting your testimony with a voice crack. Amazing. Welcome official, renewed his membership. Love it. Woo!
stayed on staff at Kearney Hospital up until actually closed 6 months ago. So
Honestly, it is better, faster, right? Just because it's just, at least there's things.
I've been on staff at Kearney for quite a long time.
And where did you go to school and what degrees did you receive?
I went to college at Tufts University in Medford, graduated in 87. From there, I went to Tufts Medical School and graduated in 1991.
And following your graduation,
It could be amusing just to put it as fast as we can. We can do we can do 2 times speed. Let's try that. This might be amusing, guys. If it gets to something important, we'll
where did you go from there?
make sure we hear it.
After medical school, I did a residency at Tufts Medical Center in 1991 to 1996.
And then where did you go following your residency?
And right from residency, I started my first job was at Kearney Hospital, which I previously mentioned, so 1996.
And doctor, are you board certified?
I am board certified in anatomic pathology and clinical
It's
pathology.
awful.
And what is a board certification?
Board certification
It's
is
a double whammy too, because this dude and Lolly, right? Now Lolly's not nearly as bad as last time. He's lost the love of Annie. He must have learned what people were saying about him. But still, it really was looking to see what the witnesses were. And I saw just I was like, oh.
is something we need to show that we are actually qualified to perform our the job that we need to do, both in anatomic and clinical pathology. It's a written exam that we take and we need to pass to demonstrate that we're competent and know what we're doing.
And first, in just general terms, if you could explain to the jury, what is pathology?
Pathology is, well, there are 2 basic branches of pathology: anatomic pathology and clinical pathology. Anatomic pathology is basically, an anatomic pathologist is a physician or MD or DO trained to make diagnoses on patients via looking at tissue biopsies, organs, tissue fluids, and we're also trained in autopsy pathology as well. So basically, an anatomic pathologist, we look at tissues via glass slides. Slides are made, and we every day make the diagnosis of somebody has a cancer or somebody doesn't have a cancer benign. Look at colon polyps, breast biopsies, pretty much anything that comes out of the operating room or a physician's office and any sort of biopsy. Clinical pathology, on the other hand, is basically a clinical pathologist is a physician, an MD or DO, who specializes in the clinical lab, which basically is any fluid specimen, including blood specimens. When you go to the hospital and you have your blood test and it gets sent to the lab, the clinical pathologist is ultimately responsible for the quality of your lab tests and quality, and basically that's it.
And so the time that you worked at Good Samaritan, did that cover the date of January 29, 2022?
Yes.
And again, what was your title and what was your job at Good Samaritan in the month of January 2022?
I was the chief of pathology at the time and laboratory medical director.
And what did you do as a laboratory medical director?
Now, having said that, I'm glad you mentioned this, Dr. Rob. The only reason it really actually does matter, believe it or not, when we get to the jury instructions, like I said, it's the most convoluted bullshit ever. There are bits in there for the fucking count 2 where actually the blood alcohol level is a factor. I do agree that it is a moot point because she said she admitted to it. However, then I'm like, oh wait, hold on, because when you look at the nitty gritty of those jury instructions, they don't make it easy for the jury. The jury is going to have to consider the actual BAC.
Director, basically, the laboratory medical director is responsible for the ultimate quality of any, either whether it's a biopsy, somebody's biopsy, or lab result. The laboratory medical director has to make sure that the final result is of excellent quality. So there are many different things that we need to make sure that things that are in place as far as need to make sure we have the correct amount of workers. You want to have enough workers. You want to make sure they're competent. So many, there are policies for competency for all the.
You want to make sure they're competent workers.
Techs and phlebotomists and even pathologists. So basically, the laboratory medical director, if something goes wrong, it's ultimately his or her fault.
And the lab at Good Samaritan, is that lab accredited?
Yes, it is.
And by what body?
We are accredited, or Good Samaritan is accredited by we call it the CAP. It's a College of American Pathologists. They are considered the preeminent accrediting body for hospitals. They've been around for probably 70 plus
Couldn't
years.
agree
or so.
more.
What is accreditation? What does that mean?
And I couldn't agree more. And that was one of the problems I had with the last time. They didn't do any of that. They need to walk that jury through the verdict slip. They need both sides. Honestly, the right thing is both sides should do it, right? In every trial, walk them through. Even when it's not complicated, we see them doing that. It blew my mind last year that neither side did any of that. I couldn't believe it.
Accreditation is basically something that says that your laboratory is following guidelines and providing excellent quality. To be accredited with the CAP, every 2 years we have a laboratory inspection. They don't.
Okay, so that nobody dies, we're gonna just go ahead because it's just 2 times. It's just not, y'all. There is some interesting stuff that comes up at one point. There he is, guys. Oh my God. Sorry. Look at his tie. Oh, mother of God. What? Y'all, look at his tie. Okay, which tie is worse? Hang on. We have his lucky tie from last year, which is his closing argument tie. He's wearing it. The Lolly Bird is wearing it. That's his closing argument tie. I think it was like his lucky tie. No, this tie is worse. If need be, I might replace the tie on the Lolly Bird and update it. If he wears this tie more, and maybe what he did. Maybe he decided that this was not his lucky tie anymore. Maybe he was like, nah, we lost because we got a hung jury and this tie goes in the garbage can. And now I replace it with a worse tie. If this is his new lucky tie, I'll have to replace this on the Lolly Bird. I've never seen anything more hideous in my life.
Is to obviously not use an alcohol swab. Normally, when you have your blood test, they cleanse the area with a swab that contains alcohol. So, in our policy, is a specific statement that says do not use alcohol swab because potentially, when you're drawing the blood, if you suck up some of that residual alcohol, you could cause a false positive. So, we have in our policy, and every hospital should have the same policy where we use a swab, a swab that has no alcohol. We call them a moist towelette. That's what we refer them to. Also, in the emergency room, my supervisor pretty much removed probably 95% of all the alcohol swabs. So, just in case the phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So,
when were the alcohol swabs removed from the emergency department?
it was before my time.
So they're saying prior to January 29, 2022.
Correct.
What is a phlebotomist and what do they do?
So, phlebotomist is a healthcare professional who specializes in drawing blood. So, they're the ones who are trained, competent, and know what to do when they draw a patient's blood.
What kind of training do phlebotomists receive at Good Samaritan?
We try to hire.
Okay, I can go ahead a little bit. He's approaching. So now we have the, again, law and crime got this extra camera thing.
Individual's blood alcohol concentration.
Oh, wow, we're already on cross. Hold on, let me back it up. Okay. Cross, yay, okay, yay. All right, so now let me put this on, like, I don't know, let's try 1.25.
53 in the morning, the result was entered into the computer. So it was ordered at 9:03, and I believe it was 9:53. The results were in the computer.
It is very interesting, and it's like I thought the same thing, Eats and Z's, but I was like, gosh darn it, it's to risk having to, like, if we were to fully listen to that, would we survive it? I don't know. So that I made an executive decision there. I also found that interesting too, that was brought up.
And may I approach again, Your Honor?
Yes.
Commonwealth will seek to introduce and admit as the next exhibit.
Any objection, Ms. Little?
All right, thank you. 637.
Your Honor, may I return to the document?
Yes.
And doctor, what was the result of the testing for alcohol?
I went back with it.
Okay.
Okay, here we go. Cross.
Thank you.
Guys, this is for 1.25 for cross. We'll see how it goes.
Good afternoon, Dr. Fowler.
Oh, good afternoon.
The Good Samaritan lab is a clinical lab, not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
I would say
I think I can put this on 1.5.
99.9% of the time, we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally, a case may come, very rare, to a hospital, and it ends up being a legal case. It's not common. I think uncommon.
You'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are conducted by law enforcement, right?
Yes.
The purpose of testing in a clinical setting is to assist in the diagnosis and treatment of a patient, right?
Correct.
And physicians need to analyze blood quickly. They need to get the results so they can see what's in a patient's system and then effectively and efficiently treat that patient, right?
Correct.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court, correct?
Correct.
You testified earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan.
In fact, Good Samaritan has never been investigated or accredited by any forensic accreditation team to ensure that you perform all of your tests with the integrity necessary to support results in court, right?
We've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
But you've never been accredited by a forensic accreditation team, right?
Nope.
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Okay. Who else died when that happened? How are you not familiar with ANAB? Are you joking me? How are you not familiar with ANAB? What is going on? And you know who else wasn't familiar with ANAB? Bev.
A forensic accreditation team, right?
Nope.
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Are you aware that ANAB is the forensic accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are
How the fuck? How? Tell me how.
reliable and credible for you?
Abby says I'm not familiar with it. Abby, that's okay if you're not familiar with it. For anyone who doesn't know, Abby is I don't want to get this wrong, like a vet tech, right? Is that, I think that's how you would say it, but she works with veterinarians. So you don't have to be familiar with it. But this dude and Judge Bev certainly should be familiar with it.
Use in court.
Sustained.
Now, the most reliable method of forensic ethanol testing is called headspace gas chromatography, or HSGC. Are you familiar with that process?
Yes.
And HSGC
I
is the
just
method.
love it. I just have to say Scroll Crew is great because we have Abby, who's a vet tech, former EMS. We have Dr. Bob, retired physics professor, and and principal. Like everybody's got all these things that they do that are awesome, and it's just we have such a wealth of knowledge here in the Scroll Crew. I just absolutely love it. We got James, who's an expert on the concrete. He's poured a bunch of aprons. It's just awesome.
That's used by forensic labs to test for blood alcohol content, right?
Correct.
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
Correct.
Can you briefly, just for the jury, describe sort of the difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out all red. That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it. That is whole blood. That is the specimen of choice for forensic blood ethanol testing. Hospitals, on the other hand, our methodology, which is just as good as the forensic headspace gas chromatography, is based on looking at the serum or the plasma. So we don't. That's what when I explained that we need to centrifuge it, take the liquid portion off the top. So in the hospital, we test it on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, Doctor. Thank you. I'll ask some additional questions to kind of clarify. In a forensic lab, they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC, right?
Correct.
And that clinical chemistry machine performs what you just testified to, a serum test, right?
Serum or plasma?
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive, it's easy to automate, but at the same time, very, very good and very accurate.
But serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right? Yes, I'll repeat that. That was my fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well, NADH is a byproduct of alcohol, right?
Correct. I can go into the testing how methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that. Alcohol testing in the lab is correct.
I'll ask you some additional questions about NADH, and we'll get there.
Yep.
So you can do this now, but let the doctor answer his question fully next question, okay? And the following questions.
Doctor, the higher the NADH in a patient's system, the higher the serum test result, correct?
That may not be correct, no. It's the rate of change of NADH production based on our methodology. I can go into that. So our test system is a little bit different than the forensic testing system, but it's also very good and very accurate, and almost when we compare our methodology to the headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this, maybe some of you might understand the chemistry behind it, but we do, we take the patient sample, and it's based on, we add, because when there's alcohol in the specimen, we add, actually in the test system, alcohol dehydrogenase. It's the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it.
I'm finding myself wishing I were dead here, so I'm gonna go. We're just gonna go ahead a little bit as he goes on and on. I will say, even though Miss Little, he elaborates and whatnot, I will say, I have noticed a huge difference. I just want to say this. Shout out to Miss Little from her last year versus this year. No offense to Miss Little. No offense to Miss Little. She's what they call a baby lawyer. Okay. Last year, when she would question a witness under either direct or cross, or even if she, piped up in a hearing or whatever, I don't think I was alone in face palming or she's trying her best, but my God, please, can we have someone else do this? It was not great. Right. But she was a baby lawyer. What has happened from my perspective over the course of time, and especially recently, they've been having her do a lot more stuff. And I've noticed it became evident in the hearings. And I think part of it is because what happened was Judge Bev hates all the defense attorneys, but she hates Miss Little the least. And so I think they started giving her more assigning her more things, right? Delegating more to her, right? And so in these hearings, as we noticed over time, this is what I noticed, right? She was speaking more. She was just, and the thing is by having that experience, right? Where she's having to argue to Judge Bev, and again, it's great because it's pretrial litigation, right? Motions practice. She's, what's the word they say? Sharpened her teeth or whatever they say it is, the thing. She's totally transformed, in my opinion, as an attorney. Her questioning is completely different. Her tone is completely different. Her, last time she had a lot of issues with, it seemed that she didn't know the ropes, right? How do you get this into evidence? And, when do you ask for this and that? And it was just very much painful for me to watch. No offense to her, baby lawyer, but her confidence level has skyrocketed. And I think she's just, I am, when I heard a little bit of this the other day with her, I was like, wow, she's a changed lawyer. She's a changed lawyer. So,
and there are limitations.
There are some limitations that I can explain, just like headspace gas chromatography may have some limitations too, but I can go into them.
Next question.
What are some of the limitations of the serum testing?
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is I, icterus, which is high bilirubin, and the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history to the patient. And
I'm glazing over a little bit. There is something interesting that comes up. Okay.
Sometimes, there can be patients who make endogenous, make their own alcohol.
This is where it gets interesting. I'm going to actually slow it down to a little bit here, because this is actually the interesting part to me. People that make their own alcohol. Yes, you heard that right. So, oh my God, not that. Okay.
The next one, sometimes, there can be patients who make endogenous, make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace. They make their own. So we have to rule that out. It's a rare condition. And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH, or lactic acid, those one is an enzyme, and the other one is an acid. That can cause false positives.
I just have to say I love chocolate.
If I could stop you there, Doctor.
Yeah, please.
I think those were the four that you identified, the four limitations: the lactic acid, the hematose.
Sorry, I can't.
If I could just
Go ahead and ask your next question.
If I could ask you a few more questions about LDH and lactic acid.
Sure.
You're aware, Dr. Fowler, of the medical literature establishing the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid or LDH actually forms NADH.
Dr. Bob, I love it. Dr. Bob is saying, so James is making banana bread, and sometimes with nuts, sometimes with chocolate chips, and Dr. Bob says, sounds really great to use shit.
Lactic acid.
Amazing.
I'll have to go into a little bit of chemistry. Lactic acid and LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing
Okay, great. This is just, wait, Siemens, what?
High levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH.
Okay.
That was first documented, I think, back in the older versions of these ethanol testings back in the 1990s, when they stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies. And
the little babies. Now I have to say, I have a cousin that died of SIDS.
For biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So it's actually, even though it's not relevant to the case at all, I actually wish we got to learn more about the thing with SIDS, because again, I have a cousin that died of SIDS, and SIDS is really they don't know what causes it, and I thought that would be interesting to learn if there was some new research, but. We won't learn.
Studies have found can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Are you aware that the medical literature has also found
Why was that? Why did he object, and why was that sustained?
that patients suffering from multiple sclerosis
I don't know.
have a twofold increase in NADH levels?
The only thing I can think about would be because of like HIPAA records or something, but clearly if the defense is asking the question, they've turned all that over and they want that to come in. So it can't be like a violation. Like, for example, if that had been asked by the Commonwealth, it could be different. But like if they're getting into like, for example, like past medical history, you know what I mean? Like there has to be reasons that comes in. But if the defense wants it in, then, I mean, clearly, I don't know. Does anybody else know what the deal is with that?
Sustained.
I have no idea.
Are you aware that the medical literature has also found?
Let me just say, I understand why he's objecting now, because they don't have to state the grounds. he doesn't want that to come in, Breen in, right? Because, or no, Lolly, I was right the first time, Lolly, because it could affect the outcome, right? It would be bad for the Commonwealth. So I understand why he objected, but I don't understand the grounds because I don't see any, and I don't understand why it was sustained. So.
That patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls.
I'm going to allow that.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not. It's not
Let him finish his answer.
It's not. It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change, and it basically, back to the anemia. I haven't.
Dr. Bob, I was literally just thinking I was literally just about to do that. That's really funny. Great minds think alike. I was like, let's listen again. Okay.
Positive alcohol, but
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So in other words, NADH, studies have found, can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
So given that, you can see why the Commonwealth wouldn't want it to then come in if Kearney has anemia, right? Because it would affect her results. So you can see why they wouldn't want that to come in. That doesn't mean they have grounds, but you can see why that, sometimes you can have an objection with actual grounds, but the real reason you're objecting is something else. For example, let's just say, as it's for the sake of example, that the Commonwealth didn't want this in because it could, make it seem like her results are higher than they should be, and she didn't really drink that much or whatever because of the anemia. But let's just say that there was another reason, a valid grounds for the objection. I'm going to just make it up as a hypothetical. Like, let's just say that it was like, I don't know. Let's just say hearsay, just for the sake of example, right? And let's just say that that was valid, a valid grounds for objection. They could object on hearsay and it could be sustained, but that doesn't mean that that has to be the reason they object, right? So my point being, the reason he's objecting is because this is bad for the Commonwealth, but I don't know the grounds yet.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Let me play this one more time.
Diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels.
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
It's not speculation because it's just a yes or no, right? It's just, were you aware? He could say, no, I wasn't aware. Now, the thing is this. Here's what I will say. Here's what I will say. The point is, I will say this. His answer here doesn't matter. The question matters, right? So the thing, I don't know that it's speculation because if he's not aware, he's not aware. Either he's aware or not. It's not speculation. But regardless, the question is the point, right? Because the jury heard it. Whether he's aware or not makes no difference. The jury now knows that that's like they heard her say that. So the question.
That Ms. Reed was severely anemic in January of 2022.
Sustained.
Are you aware that the medical literature,
he doesn't answer it, right?
Are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
So the jury's heard that. That's the point.
Sustained.
Good job, Miss Little, on that.
Are you aware that the medical literature has also found?
So now it doesn't matter. Like, in other words, it really doesn't matter whether he knew or not. The jury's now heard that if you're anemic, it can affect the results, and Karen Reed was anemic. That's the thing.
That patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls.
I'm going to allow that.
Okay.
I haven't read anything specifically related to the NADH level, but I want to go back to the point where our laboratory, our testing is not.
Let him finish his answer.
It's not. It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change, and it basically, back to the anemia. I haven't read or heard.
What? anemia. What? What's happening? Huh?
You know, back to the anemia. I haven't
Whoa.
read or heard of that.
That was stricken. That was not
Okay.
allowed.
Well, it wasn't stricken. It wasn't stricken.
It all goes back to the lactic acid and the LDH. The NAD, NADH doesn't matter. So looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study.
I'm pausing this to say that Ms. Little's job here, whenever he stops rambling, her job is now going to be to ask the same question again. Because the whole point why Judge Bev is letting him do this is for a reason, right? So that it disconnects the answer to the question. The point here is 2 points she's wanting to get across to the jury. That if you have anemia, it can affect your results, and Kearney had anemia. That if you have multiple sclerosis, it can affect your results. Kearney had multiple sclerosis, right? So we already did the first part. We're on the part about if you have multiple sclerosis, it can affect your results, right? But now we're getting this whole rambling thing. So now it's going to disconnect that to whatever the follow-up would be, which is about Karen Reed having MS. So I'm just saying, and I haven't heard this part yet. What I would say is her job, whenever he stops talking, is going to be to literally go back to her original question so that she can then ask her follow-up and connect the point there.
Maybe
Yeah, agreed.
7-10 years ago.
Your Honor, there's no question pending.
You asked him about a study, if he was aware of the
Wow.
studies.
I asked, and that's a yes or no question. And he's,
All right, Doctor, we're going to hold that there for you and ask the
Yeah.
next question.
No, ask.
Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Through Disease Course in Multiple Sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales? Which,
Do that again and slow down, please.
sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels Through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
Objection.
Huh?
I'll strike the,
What? Objection. Huh?
Specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls.
Objection.
I'll strike the part of what the article held. Is he aware of the article?
No, I'm not, to be honest. No.
Yeah, his awareness of the article doesn't matter. The point was the important part was in the question, right? Sometimes it's about the question, not the answer, right?
Dr. Fowler, did you consider Ms. Reed's anemia and multiple sclerosis condition when you
there it
conducted
is.
the alcohol test on January 29th,
That's what
2022?
No, we don't. No.
That's really probably the most important thing she could get across on this, I would say.
And again, serum tests like the ones conducted in this case don't test for ethanol. They only test for NADH, right?
We test for the rate of change of NADH production.
And Doctor, you did a number of other tests on Ms. Reed on January 29th, 2022. You tested for additional drugs, not just alcohol, correct?
Correct.
And all of those results were negative.
Correct.
Thank you. No further questions.
Okay.
There he is again. Guys, I'm gonna die. We're gonna does anybody object if we go to the next witness? Welcome, Capelli. I don't believe I've seen you in the chat before, but we're so happy to see a new scroll friend who was gifted a membership. Love that. We have a lot of generosity, and I just love you guys so much for being here anyway. And for those of you guys who gift memberships and pay it forward, love that as well. And we're just so happy to see you here, Capelli. Welcome, welcome, welcome on in. But yeah. So do you guys object to going to the next witness? Because, you know.
Doctor, are you aware, I know your lab at Good Samaritan did not do this process, but are you aware through your training and experience of any sort of mathematical conversion that can be done from a serum reading in milligram per deciliter to a blood alcohol concentration of whole blood?
I'm going to allow it. The door is open.
Go ahead, sir.
Yes, I am aware. Yep.
I mean, probably the only time that we will ever hear of a door being opened referenced in a trial, and I'm not excited because I can't, because this witness just is so painful. normally I just start getting all excited and I just, ugh.
And please describe what you're aware of with reference to that.
Feel free to join the
Well, with,
Discord as well.
blood alcohol concentrates goes to, when it's in your blood, it goes more to the watery components of your blood.
I can't. Sorry, no more watery components for me today. We're moving on. Moving on. Executive decision. No more watery components. Ugh.
Truth and nothing but the true self, God.
Good afternoon, sir.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Jason Becker.
How old are you?
I am 36 years old.
Do you live in the area?
I do. I live in Canton.
Tell us a little bit about your education.
My education, high school and college UMass. And I went to EMT school a little over 10 years ago and paramedic school.
Tell me a little bit about EMT school. How old were you when you started EMT school?
When I started EMT school,
Please tell us, do you shovel the apron?
roughly 21 years old.
Why did you decide to go to EMT school?
I wanted to save some lives.
That's a great answer right there. The way he says it. I like this dude already. And I haven't watched his testimony yet. And I don't remember. Did he testify last time? I don't remember him. Anyway, I like this dude a lot more than Nuttall. I mean, Nuttall was a mess. I like this dude. He seems straightforward so far.
How old were you when you started EMT school?
When I started EMT school, roughly 21 years old.
Why did you decide to go to EMT school?
I wanted to save some lives.
Tell us a little bit about EMT school. What did it require?
EMT school was a couple months of classroom.
I'm not getting the weasel sense from him, and that's rare for these Commonwealth witnesses. I feel like he's got. I like his demeanor, and we'll see. Could change. So far, I'm not getting any weaselness from him.
Stuff, and then you do some ride time on the ambulance. Paramedic school is a little different. It's about a little extended, 2 years worth of training. You're doing hospital, ER time, and ambulance time also.
How long did you serve as an EMT before you went to paramedic school?
I worked as an EMT for approximately 5 years.
Can you estimate how many dozens or hundreds of calls you were on during that time?
Hundreds.
Why did you decide then to go get paramedic training?
I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic school successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter.
Inevitably, what
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
On the Canton Fire Department. So I got on the Canton Fire Department, and then they sent you to the fire academy, where you train to be a firefighter.
So you had EMT training, paramedic training, and then firefighter training.
That's correct.
On the Canton Police Department, did you serve dual
What I like is he's just answering the question. He's not elaborating, and he's not getting all frilly about it.
roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir. Yes, sir. Firefighter and as a paramedic.
You served as a firefighter and a paramedic.
Correct.
In the Canton Fire Department, does it have more than one station?
There is. There's two.
Is it one station that's larger or smaller than the other?
I like
Station one is headquarters, which is larger.
Have you ever spent time at Station 1 as a firefighter or a paramedic?
Oh, yeah, we rotate to both stations.
I want you to take us
Dude.
back to January
He just answers the question. Great.
29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
Canton Station 2.
Canton Fire Station 2?
Correct.
And that's the smaller of the two stations.
It is.
Were you working with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Dan Whitley.
Was there anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. It was an engine company with 3 guys on it.
3 people were assigned to the.
The engine. Correct.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley.
I was.
What were your roles between the two of you?
Well, at the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time. So he was there to teach me.
So would Dan Whitley be the lead on the call and he would help you?
I would be the lead.
You'd be the lead.
Correct.
Did you get a call that early morning hours?
You guys,
of
I
January
just noticed
29th?
something. Y'all look. Him and Breenan. Look. Look at Breenan here. And then look at him. Are they matching? Like they're like, and I understand that it's a common thing to have like black, white, and like bluish. However, the ties are more like a specific lilac color, which I love for a tie. And also it's funny because they're like the exact same angle. And I just now noticed it. And it literally looks like if you were to just swap the heads around, you wouldn't even know that it was two different people. Isn't that funny?
2022.
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure, it's a transportation order filled out by police, doctor, basically for us on the ambulance that we have to take the patient whether voluntarily or involuntarily because they're a threat to themselves or someone else.
When you received the call for Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
I was a little
By
extended
the way,
because
guys, for anyone who's newer to the membership crew, remember that custom emojis are one of the perks. And I wish custom emojis were available to everyone all the time because I'm all about the custom emojis. I always have it maxed out at however many it'll let me do. But just to remind you guys, if you're new to memberships, then you have access to those as well.
because of the weather conditions at the time. Snowing heavily, windy, low visibility.
Okay. How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
Now, on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
Sorry, James said has never seen Nightbot using any other chat like this. I'm not sure which thing you're referencing, but whatever thing you're referencing that doesn't surprise me. I think most people use Nightbot to moderate. That's literally not like, we love Nightbot. Nightbot is a person. He has little hands but a big heart.
Police lights. Canton engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police, and they briefed us and sent us to where the defendant was at the time.
Why do you have a conversation with other first responders at the scene before you do anything?
They're making sure the scene is safe to begin with, and they're on scene first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant who was sitting in a black SUV tech car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
And what seat was the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
And the person you spoke to was in the passenger.
Okay, I'm gonna make a note right here. Okay, so this is the reason they brought him in. So that Mr. Whitley dude, remember he was the dude who talked about he did a lot of acting out on the stand, like gesturing, like she was crying with her head in her hands and da da da, and then there was the whole improper bit about what he said about Carrie, or he was saying that she said about Carrie, and then there was her not wanting to do the urine sample, and that dude basically, Mr. Whitley, was very clearly trying to get Karen convicted. I mean, that was very clear. He was very much, it was gross. Now, what's important is this dude was also there, but his demeanor is very, very different. So it will be really interesting to see what he says happened about this whole Karen Reed and the Section 12 whole thing and all this, and how it's different from Mr. Whitley, because I think he could be a really great witness for the defense.
The seat of that car. Do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
Miss Reed right there, she's in the blue, navy blue.
How long was your conversation with the defendant while she was still seated inside the vehicle?
Approximately 5 to 8 minutes.
At some point, did you and the defendant move to another location?
We did.
Where did you go?
So we went back to the ambulance.
After having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
I did.
She cooperative with that as well?
She was.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and Firefighter Whitley.
So you and Firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about what you did in the back of the ambulance and some of the conversations that you had. Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
I mean, each patient's different, depends on what the call is for. In this specific situation, it was more a psych eval, because that's what we're called for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was
Mental state of
suicidal,
mind?
and if she was, did she have a plan? Did she want to hurt anyone else? Those are some of the initial triage questions that I would ask,
Why do you ask those questions?
just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
I will notice
It's-
that Brennan says law enforcement. Every time he says it like that, I've just never commented out loud, but I can't help it anymore. He says law. It's weird.
Basically hearing them speak, hearing their story. In this specific situation, we didn't know circumstances. We just knew that Miss Reed had found her husband, which she was gone dead on the side of the road. So it was a traumatic call.
So when
He says husband.
you were there, you knew nothing about what had happened before you got there.
We did not.
I guess
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Miss Reed. And
Were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Ms. Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no.
At other times, did you speak directly to Ms. Reed?
I have.
Can you describe her demeanor or temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't mean. She just kind of said it in jest because of the events that she went through. So she was, but then there'd be periods of which she'd be calm, and then it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Objection.
Sustained.
Did she make any statements to you when you were giving her treatment or speaking to her about her husband?
Objection.
I'll allow that, it came in.
One of the reasons why she was saying suicidal stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said, but that's what she said to me.
But the last thing she said to him was an argument?
Objection.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably,
It's
did
over
you
the
get a chance to
phone,
bring her to the
probably.
hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Thank you. I have no further questions.
Mr. Jackson?
Thank you, Officer.
Charge! Because of his Civil War beard.
Good afternoon, Firefighter Becker.
Good afternoon.
When you first arrived at the scene, there was at least two Canton police officers there still.
Correct.
Do you remember their names?
Officer Saraf and Officer Mulvaney.
Okay. Their cruiser was there. You said that an engine was still there?
Correct.
And was there another ambulance there, or the other ambulance had already left the scene? They cleared.
They had already transported to the hospital.
Remind me, you were in ambulance two?
I was ambulance 2.
Got it. You parked behind the SUV where you ultimately made contact with Miss Reed, correct?
I think it was more in front of the SUV because the way the SUV was parked.
Got it. Got out of the ambulance, ultimately made contact with Miss Reed through the passenger door,
Correct.
had a short conversation with her there.
I did.
You said it was maybe 5 to 8 minutes?
More like 5 minutes because of the weather conditions.
Okay, nothing of great consequence. I'm guessing just an initial, I think you called it sort of a triage assessment?
Well, more of just introducing myself and asking her how she was doing.
Got it. And then there was one other person in the cab of the vehicle as well.
There was.
Female, male.
Female.
So there are 2 females, one Miss Reed, one another female. Did you see any other civilian females out there?
I didn't see.
Okay, so at least where you were, the contact that you had with Miss Reed and this other female, there was just 2 of them, not a third one.
From what I saw, correct.
Did you get the other female's name?
Not at the time, I did not.
Okay. By the way, have you since gotten her name?
Based on a conversation, Firefighter Whitley and Miss Reed had back in the ambulance.
Got it. Okay. And who was that other person?
Miss Carrie Roberts.
Okay. When you first observed Miss Reed, did you note whether or not there was anything unusual about her physical appearance, meaning anything on her?
She did, yes.
Describe that to the jurors, please.
She had some blood around her mouth, her neck area.
At that point, were you concerned about, obviously you're concerned mainly about her safety and getting her safely to the hospital, correct?
That's correct.
Were you worried that that might be her blood?
Well, she had said that she had given CPR to her husband.
Okay, you jumped a question ahead. I was going to say, did she tell you that it was in fact not her blood?
She did, so that kind of, in a way, ruled it out.
Okay.
No injury for me.
And you didn't notice anything about her that looked like she was physically injured or physically in harm?
I did not.
Okay. She indicated that she had given CPR, mouth-to-mouth, attempts at mouth-to-mouth resuscitation to Mr. O'Keefe, correct?
She did.
And that would account for the blood on her face and in her hair and on her neck?
That's what she told me.
Okay. And based on your observations of her, you didn't have any reason to quarrel with that?
Correct.
Okay. You indicated that her tone was somewhat rapid and repetitive. Is that right?
It fluctuated. So at times it was, yes.
Did it appear to you at that time that she had gone through a pretty significant trauma, as best you were trained at the time?
I got you.
A little bit more of a foundation. I'll give it to you.
Sure. Have you ever, in your course of training, seen individuals who have gone through some sort of a traumatic event?
Frequently.
Frequently.
Everyone's different, though.
Understood. Obviously, everybody's got their own personalities and the way of dealing with those things, right?
Sure.
Have you been able to, through your training, assess whether, at least in your belief, your observations, if someone has gone through a relatively traumatic event, as opposed to just someone whistling down the sidewalk?
Yeah.
Okay. Did it appear at that time when you're interacting with Ms. Reed that she was showing the signs consistent of having gone through a trauma?
At the time, yes.
Okay. So hence the rapid speech, the repetitive speech, things of that nature?
Correct. For the defendant, some people don't have
Understood. I'm just talking about your observations of her at that time.
Yes, sir.
Her demeanor was consistent with having gone through a significant trauma.
For the situation, sure. Yes.
Okay. You said that she went from calmness to agitation. The agitation you accounted for being, I don't necessarily want to go to the hospital. I don't want to be sectioned, correct?
She felt like she didn't need to. It wasn't, she wasn't going to act on her comments about wanting to harm herself.
You called it, I think in a report, it's SI, suicidal ideation.
Correct.
That's obviously a great concern to you and your partners when you're assessing the patient, correct?
That's right.
You don't want to leave someone on their own if they're going to self-harm, correct?
That's correct.
You pretty quickly assessed, I'm guessing, Firefighter Becker, that she was not, in fact, in the position to self-harm. That I think you said that the statements that she originally made, if John dies, I don't want to live, were not necessarily at the level of actual suicidal ideation. Is that right?
Yeah, at the time I believed it. Because the information we got and what she went through.
I'm sorry, I didn't quite understand your answer.
Sorry, can you repeat your question?
Of course. It's probably my fault. At the time that you assessed her, even though she had made some comments about if John doesn't live, I don't want to live either, you did not elevate that to the level of her being suicidal at that moment.
So I couldn't rule it out, but
okay.
I didn't think it was a huge threat at the time.
Understood.
But we couldn't rule it out, so that's why we had to take her to the hospital.
Understood. I mean, you had a Section 12. You had to take her irrespective of what you ruled in or out, right?
Right.
Okay. Firefighter Whitley was with you in the back of the ambulance the entire time you were with Ms. Reed, correct?
Not the entire time. He was before we decided transporting. He was kind of in and out, trying to find more of, talking to police officers, find more of a story of, what happened,
okay.
why we're taking the defendant on a Section 12.
Once you and Ms. Reed were in the back of the ambulance, Firefighter Whitley then joined you in the back of the ambulance?
He did.
How much time lapsed?
It was couple minutes at the most.
Okay, so it wasn't a lengthy amount of time.
It wasn't lengthy.
And he was with you during the transport, along with Ms. Reed, for the whole transport back to Good Sam.
Yes,
And you said on direct examination, I think your phrase was, all in all, she was cooperative with us.
for the majority of the transport, yes.
Okay. Never became combative. Never got physical, nothing like that.
No.
Okay. She did refer to Mr. O'Keefe as her husband or her spouse in the medical field, correct?
Correct.
You were aware at the time that HIPAA rules would demand or dictate that unless you're a spouse or a parent or child, there are certain rules against getting or providing information to someone who isn't one of those close family members, correct?
That's correct.
Okay. You previously indicated on direct examination that, I think your words were, that Ms. Reed indicated that her last conversation she had with her husband was an argument, correct?
Correct.
You've previously testified about that statement in other particulars. You're paraphrasing. You didn't write down what she said about her previous interactions with Mr. O'Keefe, and you didn't record those on a tape recorder, correct?
I wrote down in my report that she said she had an argument.
Right. You didn't write them down at the time. That was a bad question on my part. You weren't taking notes as she was speaking.
Yeah, could have been. I mean, it's kind of for every call, we jot down notes on a notepad, just
Okay.
so, when we give the staff a report, we can read off it.
Do you have those notes?
I don't.
Okay. Do you think you took notes or no?
To be honest, I'm not sure. I could have been typing them on the computer. That's what we typed the report on
Okay.
at the time.
Do you have an independent recollection of taking notes, either handwritten or on a computer as you sit here right now?
I couldn't tell you if I did one or the other. Sometimes
Okay.
I write on the computer, sometimes I don't.
Or you might not have written anything down, correct?
Correct.
Okay. So in any event, you weren't taking down, even if you were taking notes, you weren't taking down verbatim quotes of what she was saying. You were paraphrasing the information that was coming to you, correct?
That's correct.
All right. You had previously said or testified that the last time, let me rephrase that just a little bit. You previously indicated in recounting what it was that Ms. Reed actually said to you was something along the lines of she was upset because her last words to him were, because of her last words to him being in anger.
I object.
I'm going to allow the question.
Is that correct?
Well, I probably phrased it a little wrongly, the last words. It was the last conversation.
Okay, that wasn't my question. My question is a simple one. In a previous hearing, did you use the phrase, her last words to him?
Yes,
were
I did.
made?
I did.
And that was at a hearing where you were under oath, just like you are now, correct?
Correct.
That was a little closer in time than we are now. It was maybe a year ago, correct?
Correct.
Actually, my mistake. It was about 2.5 years ago. It was a grand jury, correct?
The grand jury, yes.
Okay. And the phrase that you used was, and I want to concentrate on that for just a quick second, Firefighter Becker.
Sure.
The phrase that you used at that time was that she said, quote, like her last words to him. She was upset about her, quote, last words to him. Is that right?
I object.
All right, can I see counsel at sidebar, please?
May I continue, Your Honor?
Yes.
Thank you. When you were recounting the conversation that Ms. Reed indicated that she was upset about, you also indicated, in addition to using the phrase, her last words to him, you also said that it was earlier in the night, correct? They had an argument earlier in the night.
I don't recall.
May I have just a moment, Your Honor?
Yes.
May I approach?
Yes.
Thank you. If you don't mind, take a look at the top paragraph, very, very small print. Let me know when you've refreshed your recollection.
Yes.
Okay. May I approach?
Yes.
When you wrote your report, you indicated that when she was describing the argument that you testified to on direct, it was about an argument that was, quote, earlier in the night.
Earlier in the night, correct.
Okay. And then you recounted that statement, that same statement in the grand jury later on as at least including, quote, her last words. Is that right?
Her last words.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her. And one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
She said that.
Yes.
Correct.
Okay. Were you also made aware, did she tell you that her last words to him were in voicemails. Did she say that?
She didn't give any details.
Did you ask her, what were your last words to him?
I did not.
Did she ever say whether or not she believed he ever received her last words to him?
There was no other details. There was no other details other than what she said.
Okay. But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay. In your mind, did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him, being very angry on those missed calls, those voice notes? Did you put those two things together?
I did.
Okay. Thank you. That's all I have.
Hey, Mr. Brennan?
Sir, when Ms. Reed told you that she was sad because her last conversation, or her last thing that she had said to him was an argument, did she ever suggest that was in a voicemail?
Objection.
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
I'll allow that.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection.
Sustained.
You then were interviewed, weren't you? Were you
Yes.
interviewed on February 14th, 2022?
Yes.
And you referred to the fact that she told you there was an argument earlier in the night?
Argument early in the night.
Okay. And she was telling you this when you were speaking to her that morning?
Correct. Around 6 a.m. Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No.
or midnight?
I didn't know the time.
So his answer is he doesn't know.
You testified in the grand jury, and Attorney Jackson just asked you some questions about part of the statement you made to the grand jury when he said, like her last words. Would you like to put that in context of the whole statement you made? Do you remember?
Her last words?
Do you remember the entire statement that you made in the grand jury about the statement that was made to you?
I'd have to.
May I approach?
Yes.
That was crazy when he said, would you like to
This is
put that in
page 81,
context?
lines 1 through 4. Please read it to yourself.
Great answer.
1 through 4, please.
Yes.
Now, when you made that statement you were asked about in the grand jury, you didn't just say,
Improper
like her last
question,
words, did you?
No.
You explained your memory to the grand jury?
Objection.
Ask him what he told the
Okay. The grand jury, do you know it was on April 21st, 2022?
Yes.
Okay. And did you tell the grand jury? So she
So I'm going to see counsel at sidebar for a second, please.
Oh, boy.
May I approach?
Yes.
So I'm showing you that statement that you made. That includes the last words, but there's more to the statement, isn't there?
She was upset.
I'd like you to read
Oh,
your
sorry.
entire
Sure.
statement, 1 through 5. You can read it out loud.
So she was also she was upset also because she said they had, the last time they had talked, she had gotten into an argument. So she was upset that that was like her last words to him.
And so when you were speaking about her last word to him, were you referring to the argument?
Correct.
You testified again regarding this issue, didn't you, in May 3rd, 2024?
Correct.
Right? I know.
And at that point, did you?
Also, I wanted to say on a previous live stream, we were trying to remember if there was a state grand jury and a federal grand jury. The answer is there was both. There was a state grand jury and a federal grand jury. Again, when I was doing timestamps, I noticed one of the times they said they were referencing a document and they said SGJ, which would be state grand jury. So
think or believe that the conversation she was relating to you was about a voicemail?
Objection.
I'm going to sustain the objection.
yeah,
Did you use the word again on May 3rd, 2024, argument?
Objection.
I'm going to allow this.
I used argument.
May I approach, Your Honor?
Yes.
Can I ask you to read your prior statement on page 10? line 9 through 13.
Objection.
I'm going to see you at sidebar again and bring these documents, please. Bring all of it.
Wow. Okay. Spicy court time.
May I?
Yes.
Thank you. Sir, when you wrote the report of your notes to put in your report, do you remember the word argument?
I did.
Do you remember her actually saying the word argument?
I did.
Do you remember her ever saying any word about voice messages?
I did not.
You said that there was somebody in the front seat of the car with the defendant,
There was.
and you later learned from the defendant it was a person by the name of Kerry Roberts.
Correct.
Can you share with us the context? How did you learn that?
The defendant in,
I'm gonna back this up here a second. So Twiz is asking why so many sidebars. So, you know, when they're objecting, right, they can't state their grounds. So one of the things when they were talking about wanting, well, the defense was wanting to be able to state grounds for objections, which, as we all know, this is completely unusual, right? One of the arguments that Mr. Nuttall made was it would save time because when there's an objection and they can't argue the objection, right? Because they can't state the grounds, they have to go to sidebar. So the reason they're having to go to sidebar is because Alan Jackson is objecting a lot, right? And he can't state the grounds and they can't argue it. Normally, you know, what you hear is objection, hearsay, and then the other side might be allowed to respond. Sometimes the judge will just rule, and I'm saying in other trials, not here because they don't state their grounds, but other times they might say, okay, what is your response? And they can say, you know, Your Honor, it's not hearsay because it's not being offered for the truth of the matter asserted, for example, right? And then the other side might get, and then they say, okay, well, what do you say? And then the other side gets to say, it is offered for the truth of the matter asserted, blah, blah, blah. They get to argue about it, right? So when there's objections like this that are coming fast and furious, as she said, you know, and all they can do is say objection and that's it. They can't have argument about it, but the other reason additionally is to preserve it for the record, because the grounds of the objection are important for appellate purposes, and they can't get those on the record because they can't say them out loud. The only way to get their objection on the record is to go to sidebar. So one of the things, again, that was talked about was like, look, if you're not going to allow the grounds in, we're going to have a fuck ton of sidebars because we want to make sure we get the nature of our grounds for the objection in the record. So that's the other reason. So even if they're not going to really argue about it per se, it's still important for appellate purposes that they get the nature, the grounds of the objection into the record for appeal should she get convicted. So.
It was.
And you later learned from the defendant it was a person by the name of Kerry Roberts.
Correct.
Can you share with us the context? How did you learn that?
The defendant and my partner, firefighter Whitley, had a conversation.
Objection.
I'm going to allow it.
So the defendant brought up how if her husband had died at the time, she didn't know how she was going to take care of his kids.
Objection.
I'm going to allow this.
And firefighter Whitley mentioned that she had like a strong support system. You know, all the friends are on Canton, and
And this is one of the things, actually, Runkle made a good joke about this, how it's like, if you're the defense, literally every single time there's objection, just be like, we have to approach the sidebar to get because it's not all of them they're getting into the record, right? They're not approaching after all of them, but they could. And they could do, the point being, they could do that to try to get Judge Kearney to change her ruling, right? Because it's like going to be a lot of approaching. I mean, like literally, that could be a strategy. Like every single time there's an objection, we're going to approach and we're going to be here for a fucking year. You know what I mean? However, the defense is not doing that, but they are picking which ones they want to approach. I mean, like technically speaking, all of these should be on the record, and they really could approach and probably should for every single one, if for no other reason, just to get the grounds for the objection on the record. And so, yeah. Too fast? We have missed you. Where have you been? Are you okay? I'm so happy you're back. Thank you so much for gifting memberships. More importantly, how are you? And we're so happy to see you. Is she crazy? Yes. Right? Twiz asking a great question. Why wouldn't they allow the reasoning then if it's so important for appeals? Yup. It is extremely important for appeals. extremely important. Because here's the thing. When you have an appeal, in every single case, with only one exception that I know of, and that's Alex Murdoch, where he has the same attorneys working on the appeal, with every single other case that I've ever heard of, you always have new appellate attorneys. So these appellate attorneys, here's how this works, guys. Appellate counsel, they don't watch the trial. I don't even think they can watch the trial. They can only go off of the court transcript. And these appellate attorneys know nothing about the case. So literally their job is to scour the transcript of the entire trial, every single word. But they have no context for the case. And they also have no context for things like the tone of voice, right? So literally when it comes to objections, they have no idea why an objection might be especially important or not. And that's why the grounds matter, because when they're going through the transcript and they see the grounds for the objection, then that triggers them to see if, for example, the judge, for example, maybe sustained or overruled an objection that should have been the other way around, right? For appeals, they're looking for any possible issue that they can raise on appeal. And, a lot of times certain objections, things being let in or kept out, doors being opened, those are hugely important. And so they don't know what to look for if they don't see it in the transcript. And that's why one of the biggest and most important jobs you can have as trial counsel for the at this level, at this court level, when you're having the trial, one of the biggest things you can do is to make sure you preserve everything on the record for appeal. So that way you're giving the appellate counsel the best chance possible to find errors. Interesting training with the witness protection program. Okay. But we are happy you're back too fast. I don't know what picture you're referencing. We got a capital T. Of course, we have the Twiz emoji. But yeah, so it is why they would be completely warranted to approach at every objection, right? They really could. And some might say should, it's crazy. This is crazy. And the fact, because Judge Bev has this rule, it allows her to rule in whichever way she wants. And as we know, it's oftentimes going to be in the favor of the Commonwealth and without having to be questioned. And there's twofold there. Without being able to be questioned at the time of the objection. For example, if the Commonwealth just objects and she just sustains it, and that's it, they don't even know what the grounds are, right? She can just choose what she wants to do without ever being questioned at the time, and also at the appellate level, because nobody knows what if the appellate counsel doesn't know what the grounds are, then they don't know if the judge was correct in sustaining or overruling an objection. It's insane. Oh, if you're talking about the Twiz emoji, yeah, that's when he was there for that hearing on April 9th. They're approaching again. Jesus Christ.
When you spoke to the defendant and she shared with you that her last words with her husband were an argument, why didn't you ask for more detail about that?
I didn't feel it was at the time we went about the call as that we didn't think we would be witnesses in a murder trial. We were there to support Garrey and ultimately get to the hospital safely.
And you were asked about trauma, and you said that you observed that the person may be in trauma. Ms. Reed.
A traumatic event,
traumatic event.
Right.
Do you have any idea what caused that traumatic event?
I did not.
Thank you. I have no further questions.
Anything?
Cross.
You indicated that you were asked on redirect examination by Mr. Brennan whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked, yes.
And earlier in the night could have been 6 o'clock p.m.
They're allowed to do that.
Correct.
Could have been
You're
5
allowed
o'clock
to do that.
p.m.
Could have been.
Could have been 7 o'clock p.m.
Sure.
Okay. You were also asked whether or not Ms. Reed actually specifically mentioned voicemails when she talked about those last words. And you said she didn't.
That I remember, correct.
But she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John Keith, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained. All right. Jurors disregard that last statement.
Hold on.
All
Let
right.
me hear that was. She's hold on.
I wasn't gonna look through her phone. I don't know who she called.
Thank you.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained. All right. Jurors disregard that last statement. All right. You are all set.
Those were the last words, the argument. Oh, because he's trying to get to the timing of it. A lot of this too is probably objecting for speculation because they're really what the Commonwealth is trying to do is get this dude, this witness, to say when this argument happened, and he doesn't know, and she wasn't specific, and he's not a mind reader, and anyway, it's just yeah, okay.
Set.
All right. Thank you.
Is this a good place to stop for the day?
If the court pleases, yes.
Jurors, we could do 6 minutes, but I think this is probably a good place to start.
I don't think they put
Especially a trial this long. We've decided that we're going to spend Monday afternoon again trying to streamline this trial and deal with issues that we have to deal with. So
Arc of voir dire on
will be a half
Monday.
day. All right, so I just want to
Again, Monday we have to have testimony to the half day of Arc of voir dire. Holy fuck.
tell you that before you left today. Please, again, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. And I guess the 4th caution is the same as I've been saying. Please be very careful with your social media. All right. Have a good weekend. We'll see you Monday morning.
All right, everyone, please.
And I'd like to see counsel at sidebar, please.
And I don't think they put anything else on the record. Let's just see.
All right. We'll see you Monday.
All right. Good night, Dr. Bob. What?
All right.
Okay, so now I need some of these. I hope you're still here. So now, as per request, we're going to take a look at this Turtle Boy affidavit, and then we will get into the verdict forms and the jury instructions. And after that, this will redirect you guys automatically through the powers of technology into the next stream, which will be we are going to watch Nicholas Balance's testimony, FBI cast from the Chad Daybell trial. And I was trying to decide if we would utilize the testimony from Lori's or Chad's trial. I decided to do Chad's because then you can actually see his PowerPoint presentation. And of course, there were not cameras allowed in Lori's trial. So that will redirect you guys. But for now, let me pull this up. Just have to unshare, reshare. Okay. So here's Aidan Kearney's affidavit. Aidan Kearney. Okay. My name is Aidan Kearney. I reside in Massachusetts. Okay, fine. Okay. I've been friendly with Catherine Peter here and after Peter for close to a year. I've had multiple conversations and face-to-face interactions with Peter. Peter volunteered information to me about the Carey case countless times throughout our friendship. All factual representations below are from what Peter told me about her involvement in the Karen Reed and Aidan Kearney cases. During Karen Reed's first trial, she was in regular communication with ADA Adam Lawley. At one point prior to jury deliberations, Peter met with Adam Lawley for lunch. During this lunch meeting, Adam Lawley told Peter that he knows the foreperson is a retired police officer and he, the juror, is guaranteeing a mistrial. This is what was verbally reported to me by Peter. Guys, she told me she is paid $1,500 each month via Cash App for her assistance in the Karen Reed and Aidan Kearney prosecutions. Peter believes that Karen Reed is innocent, but she has to, quote, play the game, end quote. I interpret this to mean Peter's role is to publicly promote and advocate on social media that Miss Reed is guilty. Peter opined to me that if anyone killed John, it was blank an asshole. I wonder what that was supposed to say. Peter is very close with Hank Brennan and has had multiple conversations and meetings with them. I've personally heard Peter on the phone with Hank Brennan. During a phone conversation between Peter and Hank Brennan that I was present for and personally recognized Hank Brennan's voice, Peter told him that her, quote, people leaked it to the media, end quote, referring to the federal investigation being over. As of April 15th, 2025, Peter is, quote, not talking directly to Hank anymore. We're using a third party to communicate now, end quote. Peter states that she's untouchable because of everything she's doing to assist the prosecution and that no matter what violations I'm charged with, Morrissey's keeping me out of jail. Peter asked me to go stalk Karen Reed in the Seaport with her and stated that Karen Reed stays at the Omni Hotel. She stated to me that we can take photos to sell to the Daily Mail and that she's done that before. Peter informed me that Jennifer McCabe bought her brand new sectional as compensation for her assistance. What does that mean? Brand new sectional? No idea what that means. Peter is oh fuck, what was her first name? Catherine Peter. Peter was told by Jen McCabe that Jennifer McCabe informed Michael Morrissey that she is not testifying unless Turtle Boy is in jail. Michael Morrissey informed Jen McCabe that he would he would have to subpoena her, and Jen McCabe then told Michael Morrissey, then we won't say what you want us to say. Oh, fuck. Peter got rid of her phone, of course, the day after Aidan Kearney announced on his live show that he was looking to get personal communications with Michael Morrissey. Peter said to me, they will never get the communications between me and Morrissey. The day that Peter showed up to protest at the Karen Reed trial, Peter informed me Jen McCabe paid me for her show of support. On March 16th, 2025, Peter told me that she went to meet with Michael Morrissey and Jen McCabe at an undisclosed location in Braintree. When Peter returned home, she had a manila envelope in her hands. Oh, good Lord. Peter has informed me that she has seen emails that are subject to a protective order between the Karen Reed prosecution team and Jennifer McCabe. Peter reported to me that upon request of Hank Brennan, she provided the spreadsheet of all of the Free Karen Reed Facebook supporters to the Commonwealth for this upcoming trial. Peter told me that Hank Brennan is providing information to the federal authorities regarding Karen Reed and Aidan Kearney because he wants them in jail for the trial. Peter told me that she's going to start rumors about jurors being afraid to serve because Turtle Boy will go after them, and everyone is working overtime to make sure that Turtle Boy can't be in the courtroom for the trial. Peter admitted to me that she created the image of Karen Reed and Alan Jackson embracing that was given to the Daily Mail. In early January, Peter and I were discussing the Lindsay Gattani case against Aidan Kearney. I mentioned something about Gattani, I don't know if I'm saying that correctly, being pregnant at the time, and Peter interrupted me saying Lindsay was never pregnant. I'm aware that Peter and Gattani were close friends in the past and worked together against Mr. Kearney. I understand that I'm not represented by any attorneys connected to the Aidan Kearney or Karen Reed defense teams. I understand that I'm not represented by any attorneys connected to the Aidan Kearney or Karen Reed defense teams, and that I'm turning over this information because it's important to know the truth about what's going on. I'm not being coerced or compensated, and I'm doing this of my own free will. Hang on, isn't this? Oh, we don't know who this affidavit is from. Okay, so this is not, I was thinking this is Turtle Boy's affidavit, sorry. No. This is, I need to read this again. We don't know whose affidavit this is. Wow. Okay, let's read this again. So the undersigned, okay. They reside in Massachusetts. They're of age. Okay, I've been friendly with Catherine Peter for close to a year. I've had multiple conversations, face-to-face interactions with Peter. Peter volunteered information to me about the Karen Reed case countless times throughout our friendship. All factual representations below are from what Peter told me about her involvement with the Karen Reed and Aidan Kearney cases. During Karen Reed's first trial, she was in regular communication with ADA Adam Lawley. At one point prior to jury deliberations, Peter met with Adam Lawley for lunch. During this lunch meeting, Adam Lawley told Peter that he knows the foreperson who is a retired police officer and that the juror is guaranteeing a mistrial. This is what was verbally reported to me by Peter. She told me she's paid $1,500 each month via Cash App for her assistance in the Karen Reed and Aidan Kearney prosecutions. Peter believes that Karen Reed is innocent, but she has to play the game. I interpreted this to mean that Peter's role is to publicly promote and advocate on social media that Ms. Reed is guilty. Peter opined to me that if anyone killed John, it was blank an asshole. Peter is very close with Hank Brennan and has had multiple conversations and meetings with him. I've personally heard Peter on the phone with Hank Brennan. During the phone conversation with Peter and Hank Brennan that I was present for and personally recognized Hank Brennan's voice, Peter told him that her people leaked it to the media, referring to the federal investigation being over. Again, there's still questions about that being true, right? As of April 15th, 2025, Peter is not directly talking to Hank anymore. We're using a third party to communicate now. Peter states that she's untouchable because of everything she's doing to assist the prosecution. And no matter what violations I'm charged with, Morrissey is keeping me out of jail. Peter asked me to go stalk Karen Reed in the seaport with her and stated that Karen Reed stays at the Omni Hotel. She stated to me that we can take photos to sell to the Daily Mail, and she has done that before. Peter informed me that Jennifer McCabe bought her brand new sectional as compensation for her assistance. Yeah, I guess the reason I was is a brand new. Shouldn't have the word a there. Anyway, Peter was told by Jennifer McCabe that Jennifer McCabe informed Michael Morrissey that she's not testifying unless Turtle Boy is in jail. Michael Morrissey informed Jennifer McCabe that he would then have to subpoena her and Jennifer McCabe, and then told Michael Morrissey, then we won't say what you want us to say. If they're subpoenaed, they mean. Peter got rid of her phone the day after Aidan Kearney announced on his live show that he was looking to get personal communications of Michael Morrissey. Peter said to me, they will never get the communications between me and Morrissey. The day that Peter showed up to protest at the Karen Retrial, Peter informed me Jen McCabe paid me for her show of support. On March 16, 2025, Peter told me that she went to meet with Michael Morrissey and Jen McCabe at an undisclosed location in Braintree. When Peter returned home, she had a manila envelope in her hands. Peter has informed me that she has seen emails that are subject to a protective order between the Karen Reed prosecution team and Jennifer McCabe. Peter reported to me that upon the request of Hank Brennan, she provided the spreadsheet of all the three Karen Reed's Facebook supporters to the Commonwealth for this upcoming trial. Peter told me that Hank Brennan is providing information to the federal authorities regarding Karen Reed and Aidan Kearney because he wants them in jail for the trial. Peter told me that she's going to start rumors about jurors being afraid to serve because Turtle Boy will go after them, and everyone is working overtime to make sure that Turtle Boy can't be in the courtroom for the trial. Peter admitted to me that she created the image of Karen and Alan Jackson embracing. In early January, Peter and I were discussing the Lindsay Gattini. I'm going to say Lindsay, okay, case against Aidan Kearney. I mentioned something about Lindsay being pregnant at the time, and Peter interrupted me saying Lindsay was never pregnant. I'm aware that Peter and Lindsay were close friends in the past and worked together against Mr. Kearney. I understand that I'm not represented by any attorneys connected to the Aidan Kearney or Karen Reed defense teams, and that I'm turning over this information because it's important to know the truth of what's going on. I'm not being coerced or compensated, and I'm doing this of my own free will. Well, well, well. Guys, let me see what you guys are saying in the chat. I did say Turtle Boy Affidavit. That was my bad. Well, here's the thing. The way this is being talked about is it's being called the Turtle Boy Affidavit. So, and then also I saw Aidan Kearney and I saw Affidavit of, and my brain went affidavit of Aidan Kearney, but also everyone's calling it the Turtle Boy Affidavit. And I mean, it's for Turtle Boy, but it's not his affidavit, but it's calling it that sounds like it's his affidavit. I thought it was his affidavit, but it's not. So that's why I corrected myself. Who turned this in? We don't know. They're redacted. We don't know. And I don't blame it for being, I mean, this is a huge deal. This person needs to go and do it like witness protection, probably. No, it's not what? Yeah, it's definitely a lady, and their name is redacted, obviously, like, right? That's what we said. So, no. Look, hold on. Right here. I understand that I'm not represented by any attorneys connected to the Aidan Kearney or Karen Reed defense teams, and that I'm turning over this information because it is important to know the truth about what is going on. I'm not being coerced or compensated, and I'm doing this of my own free will. A third party from what this says. Wow. Wow. This is going to be very interesting, guys. So there's the witness, but again, we don't know who this person is. Wow. Right. That's correct. I mean, it doesn't have a, a docket number or a, anything like that. But yeah, I mean, dude. Right. I mean, that's all we know. That's clear. That we can figure that out from context clues. A woman who was friends with Kate Peter. Yep. That's what we can figure out. It seems like up until recently. When was the most recent thing on here? Early January. But even we got March 16th, 2025. We've got April. The most recent date on here is April 15th, 2025. I mean, that's just from that's from 10 days ago, guys. So this person is still friends with her, at least enough to get this information at this point, right? That's the most recent date we have. I mean, it's only 10 days ago. Wow. So she decided since then, right, to file this affidavit. This is crazy. Well, she does now. This just got filed. Well, this is, again, it doesn't have, now having said that, if this was submitted over the weekend, that would be why it doesn't have a docket number on it yet. Wow. But I guarantee you this has been given to her. There was other times where things were filed over the weekend, right? Remember right before trial started, the Commonwealth filed 4 motions over the weekend, and she came in first thing Monday morning or whatever, Tuesday morning, and said, there were 4 documents filed over the weekend. And so she's got this. Dude, what is going to happen? Holy shit. Correct. But my point being that this girl, this lady, was still close enough and friends enough with Kate Peter to have to get this information. And this is as recently as 10 days ago. That's my point. Like, in other words, I don't know that we can even say it's an ex-friend, right? Because an ex-friend, unless they're ex-friends as of April 16th, right? Because that's why I was looking at the date. Like, for example, because the recency of the information would show how recent they were still friends, right? Wow. I have no idea who that is. Is that a real person? Okay, so now we're going to take a look. Jesus Christ. Wow. Monday's going to be interesting, guys. Monday's going to be very interesting. Will the jury even come in at all? Will they have to deal with this? Maybe. Fucking hell, dude. What a mess. Okay, so we're going to take a look at this. And then again, this should redirect you guys afterwards into Agent Balance's testimony. Okay, let me pull up. I'm getting all these things ready here. Okay. All right. Verdict slips from last year. These will be exactly the same, unless the Commonwealth drops charges in the middle of trial or something, to say, okay? I mean, it's a lot. I mean, and fixing the jury, of all the things that like are of immediate issue for the trial, like fixing the jury. Fixing the jury? Okay. All right, so verdict slip. So murder in the second degree. Okay. This is obviously the most basic, but let's take a look at what needs to be proven for this one. Okay. Okay, so murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. The defendant caused the death of the victim. The defendant intended to kill the victim or intended to cause grievous bodily harm to the victim or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. So this is where it gets a little bit funny, right? It's like, we're going to break it down, right? So let me pull up the PDF. Okay, hang on. There you go. Okay. So I think it's on page 50. Yep. All right. Okay, so the part that's more complicated, right? Okay, here we go. The fourth element is that the defendant intended to cause grievous bodily harm, and here's the thing, right? Intended to do an act which is circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Now, some of this doesn't apply here. We don't need this. This doesn't apply because, again, there's no first degree murder. Okay, the second point is that the defendant intended to cause grievous bodily harm to the victim. Grievous bodily harm means severe injury to the body. Intends to cause severe injury to the body, basically, right? The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. In this case, what would that be? The collision, right? If you find that he or she intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Well, that involves speculation, but anyway, then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act in which the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by the consumption of alcohol or drugs. That doesn't apply. Oh, hold on. Sorry, that was okay. I think it's all the same here anyway. So that was actually first degree, but I think those prongs are the same. Hold on. It was supposed to be page 50. Let me see here. Yeah, I mean, I was reading this part about the grievous bodily harm. So, okay, let me scroll to get to the next part here. So we're getting to sudden combat. Let me pull up, hold on. Oh God, I didn't mean to click on that. Hold on. Okay. Now let me pull up, where did it go? The verdict form 2. Okay. Give me just a sec. Okay, so here's the count. Here's count 2. Manslaughter while operating a motor vehicle while under the influence. This is where it gets complicated. So that has its own, they don't make it's not, okay. I have to open a separate PDF. Hold on. This whole thing. That has its own complete fucking thing. So that is gonna be one 5.1. Okay, I think it's this one. Okay. Okay. Great. This is it. This is what I needed. This is what I needed. Motor vehicle homicide. Okay. Motor vehicle homicide, felony, OUI. There's a bunch of these documents, guys. I'm just getting, they're all separate. It's just, they don't make it easy here. That's the negligence. And then let me just look. This is the involuntary manslaughter. Okay, let me undo reshare. Okay, so manslaughter while operating a motor vehicle under the influence. So the lead charge here is this. This is the voluntary manslaughter. So, okay, the elements here. So 1, the defendant intentionally inflicted an injury or injuries on the victim likely to cause death. 2, the defendant caused the death of the victim. 3, the defendant did not act in proper self-defense or in the proper defense of another. Now, okay, remember when we were talking about the BAC? Hold on. I hate that I have to keep unsharing and resharing. It's so frustrating, but there's no other way to do it on StreamYard. Okay. All right. Look at this. So this is for count 2. This is the most confusing one, right? So either not guilty or guilty of the offenses charged. Manslaughter, but you have 2 options. Manslaughter while operating a motor vehicle under the influence. Check 1 or both of the following. The first one, manslaughter while operating a motor vehicle under the influence of alcohol and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. So remember how we said, earlier, like she's already said she was buzzed. We know she was drinking, But then it was like, so why are they calling this dude to talk about the BAC level? This is exactly why. Because they can choose one or both of the following. They can basically say, we don't care about the BAC, we find the first one. Or they can say both. They can check one or both of the following. So now that takes us to here. That takes us to here. I wasn't joking when I said they made this as convoluted as possible. We're just getting started. All right, this is it. So this is the felony OUI liquor and recklessness. Okay, because remember, there's reckless and there's also negligent. The defendant is charged with motor vehicle homicide. To prove the defendant is guilty of this offense, the Commonwealth must prove 5 things beyond a reasonable doubt. First, the defendant operated a motor vehicle. Second, the defendant did so on a public way. So like a regular, road, right? That is kind of self-explanatory. Third, that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor. Fourth, that while operating a motor vehicle, the defendant did so recklessly so that the lives or safety of the public might be endangered. Fifth, that the defendant's acts caused the death of another person. Now, why is this especially, well, let me keep reading and then we'll talk about it. To prove the first element, the Commonwealth must first prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all the well-known things that drivers do when they travel. A lot of this is self-explanatory, right? They're driving. Okay, fine. To prove the second element, they must prove beyond a reasonable doubt that it was a public way. Again, we're not going to read all of this, just so we know. To prove the third element, they have to prove that the defendant was under the influence of intoxicating liquor. That is alcohol while operating motor vehicle. What does it mean to be under the influence of alcohol? This is the one, remember, that is irrespective of the BAC, right? That the jury could find she was intoxicated regardless of what the BAC said. So for example, her saying she was buzzed. It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. It means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. The amount of alcohol necessary to do this may vary from person to person. Do you see how gray area is an understatement this is, right? Isn't this crazy? Oh, I love the harpsichord. Sorry, it's hard to read the chat, as y'all know, when not exactly though, need some Z's. Not exactly. This is where it gets to I'm getting ahead of myself. We'll talk about it. Let me keep reading. Okay, so the amount of alcohol necessary to do this may vary from person to person. You may rely on your own experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. To prove the fourth element, the Commonwealth must prove beyond a reasonable doubt that the defendant drove recklessly in a manner that might have endangered the lives or safety of other people. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or if they are indifferent to whether someone may be killed or seriously injured. There's languaging in here that allows for her to not have hit him with her car, guys. Pay attention. I want you to think about this. The languaging in here can allow, if the jury finds this, they could, if they pay really close attention, they could find her guilty of this, even if they think she didn't hit him. Okay? Let me read this person again. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone may be killed or seriously injured. Just being indifferent counts as driving recklessly. Like that means, like, for example, someone else could have come and killed him. Like that's what this says. They're indifferent to whether someone may be killed or seriously injured. Not even by the same person. Do you see what I'm saying? It doesn't say it has to be by the same person. It is not enough for the Commonwealth to prove that the defendant acted negligently, that it's acted in a way that a reasonable person would not. Rather, it must be shown that the defendant's actions went beyond negligence and amounted to recklessness. The defendant was reckless if they knew or should have known that such actions would pose a grave danger of death or serious injury to others. Not even, doesn't say it has to be from them. But they chose nevertheless to run the risk and drive in the manner that they did. Do you see what I mean? So for example, her just speeding off and someone else killing him, the jury could find this applies. Y'all see? In determining whether the defendant drove recklessly in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition and how well they could see and control their vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, the road conditions, what any other vehicles or pedestrians were doing, and any other factors you think are relevant. The defendant must have intended their acts in the sense that the acts were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts. I don't like this at all because it literally leaves room for somebody else to come in and do a killing, and then the person, like, it's crazy. It is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that the acts were so dangerous that death or serious injury to the other people would probably result. To prove the fifth element, the Commonwealth must prove beyond a reasonable doubt that the defendant's acts caused the death of another person. This requires the Commonwealth to prove two things. First, the Commonwealth must prove beyond a reasonable doubt that the death would not have occurred but for the defendant's acts. Again, if the jury finds that he died because of hypothermia, because he was left in the snow, because she drove off, even if she didn't hit him, I'm just saying, I don't like this. I don't like this at all. I think this is incredibly confusing, complicated, vague, subjective, and problematic. But this is what it says. So they must prove beyond a reasonable doubt that the death would not have occurred but for the defendant's acts. The Commonwealth must prove that the defendant's conduct was necessary to bring about the death. If the death would have occurred without the defendant's acts, the defendant is not responsible for that death. Second, the Commonwealth must also prove beyond a reasonable doubt that a reasonable person in the defendant's position would have foreseen that their conduct could result in serious injury or death to a person. The Commonwealth does not have to establish that the defendant foresaw or should have foreseen the exact manner in which the injury occurred, but the Commonwealth must establish that the death was a natural and probable consequence of the defendant's acts. Now, to the, this is the hypothermia and the timing of being in the lawn and all that is going to matter, right? You can see why, potentially, when you examine this, we all have said this whole third-party thing is maybe a distraction from the Commonwealth not proving their case, and I still think that's true. However, when you really examine this jury instruction, it does actually, it could be why it is so important for the defense to show that he was not in the yard the whole time and that he went in the house, right? Because of the but for. If he went in that house and something else happened there, right? Or if he didn't have hypothermia, then they can't even find her. There's no way that she could be responsible, right? And it goes to the Commonwealth's theory. The Commonwealth's theory is he died because he was left in the snow after being hit. But also again, that's why I'm saying the being hit part would go more to the first charge, right? The second-degree murder, the intentional part. So far, all of this here on count 2 does not require her to have hit him. You could find it. You could interpret it that way. It's going to be up to the jury how they, you can, this is the law though, right? Like, you could interpret this either way. You could find that she hit him and this still applies, or you could find potentially that it still applies even if she didn't hit him, but because of him die. If you believe that he died in the snow due to being left there with the hypothermia. Okay, so let's keep reading. A defendant whose act was fully capable of causing a person's death should not be acquitted simply because of another sufficient cause. Oh, sorry, that's still going with this example. We don't need that. Okay, they have to prove all 5 elements. The fact that an accident occurred is not by itself evident that the defendant was reckless. You must examine all of the evidence about how the accident happened in order to determine whether recklessness was involved, and if so, whether the recklessness was the defendant's. Again, if he went in the house and other people were being reckless, then that would matter here, right? An emergency situation, I think the rest of this doesn't actually apply. Oh, here's the sobriety. Okay, I think the rest of this we don't need. So let's just revisit this one more time here. The defendant operated a motor vehicle. The defendant did so on a public way. Check. These are not going to be at issue, right? That while operating a motor vehicle, the defendant was under the influence of intoxicating liquor. Again, I think that no one's going to dispute that. So the first 3, I think check. Okay. While operating a motor vehicle, the defendant did so recklessly so that the lives or safety of the public may be endangered. Again, when we're talking about what the Commonwealth has to prove, when it comes to this count, right, this charge, elements 4 and 5 are going to be the things at issue. Was it recklessly? Was she operating a vehicle recklessly? We're going to take one more look again at what the recklessly thing. And then the acts caused the death of another. Again, the act here isn't collision. It's just by were you being reckless. Okay, so we're going to go again to the reckless part, element 4, just to review it. This is complicated. Okay, drove recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone may be killed or seriously injured. It doesn't say because of hitting them or whatever, right? It's just their driving can cause it. So for example, driving off in a car. I'm just saying that's, you could interpret it this way. They don't get help, right? They're given these instructions and then they can interpret them from there. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that that a reasonably careful person would not. Rather, it must be shown that the defendant's actions went beyond negligence and amounted to recklessness. The defendant was reckless if they knew or should have known that such actions would pose a grave danger of death or serious injury to others, but they chose nevertheless to run the risk and drive in the manner that they did. This languaging here, I think, really helps the Commonwealth, because if the jury thinks she was, if the jury is like, yeah, she was drunk, it was snowy, she should have been more careful. If they think that, if they don't like her and they're going that route, you can see how this would be like, yeah, that's reckless because of the languaging here. I don't like that languaging. Now, these are the model jury instructions. This could be changed a little bit. You know, we'll hear all that at the end. But anyway, I don't think that I think it was pretty much the same last time anyway. In determining whether the defendant drove recklessly in a manner that might have endangered the lives or safety of other people, you should take into account the evidence, if any, about the rate of speed, right? Physical condition, how they could see, the condition of the defendant's vehicle. So was the vehicle falling apart? Doesn't apply here, right? What kind of road? The weather. Why did they keep harping on the weather? Why do they keep harping on the weather, guys? Right here. Because they want to be able to make the argument, they being the Commonwealth, that given the weather conditions, the reasonable standard changes. That you should have been even more careful. That's what they're going to say. And the road conditions. The roads were fine. There was nobody else on the road. It's the weather, and then the time of day. It was dark and weather, right? The defendant must have intended the acts, as in driving, in the sense that the acts were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts. So as long as a reasonable person would know that the acts were so dangerous that death or serious injury to another person will probably result. And then here's the last one again, the fifth element. They have to prove the death. So the Commonwealth has to prove two things. The death would not have occurred but for the defendant's acts. Again, this is where third-party culprit comes in. That takes away the but for on responsibility for Karen, right? If the death would have occurred without the defendant's acts, the defendant is not responsible for that death. By really reading this, honestly, I think that I'm going to be a little bit more forgiving with the third-party culprit thing, because I can see why that really matters in the second charge. It's really making me kind of rethink how I feel about that, because you can see how that's really necessary. Because if the jury really sits and dissects this, the Commonwealth does not have to establish that the defendant foresaw or should have foreseen the exact manner in which the injury occurred. But the Commonwealth must establish that the death was a natural and probable consequence. Probable consequence. Probable consequence. Isn't that crazy? It's not like fuck beyond a reasonable doubt. That's wild to me. The Commonwealth must establish that the death was a natural and probable consequence of the defendant's acts. That's insanity. A probable consequence? Oh, God. Oh, God. Oh, God. Oh, God. Okay. So then we have the instructions here for the blood alcohol levels. So let me pull this up. Okay, so this is the other one. So looking at, again, if I pull up, remember how they could check one or both boxes on the verdict form? Hold on. Okay, so remember to check one or both. Here's where we're at on count two, by the way, guys, all of this. Here's where we're at. We have just covered, can you see with the lethal hand? We have just covered this. That's where we're at. Now we're on to this. Manslaughter while operating a motor vehicle with a blood alcohol letter of 0.08 or greater. All right, unshare, reshare. Convoluted is an understatement, people. All right, so the defendant is charged with motor vehicle homicide. To prove the defendant guilty of this offense, the Commonwealth must prove 5 things beyond a reasonable doubt. First, this is exactly the same as the one we just went over, with the exception of number 3, like 3, 4, and then 5. So, okay, third, while operating a motor vehicle, the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so negligently instead of recklessly, so that the lives or safety of the public might be endangered. And fifth, and then the fifth element is the same. So elements 3 and 4 are the differences. And I actually remember when she was reading the jury instructions, I remember her saying that. I remember that. And we talked about this, right? The third and fourth elements are the differences from the one we just read. So this is about the blood alcohol level and then negligent versus reckless. And again, they can find both this one and they can find both reckless and negligent. It's craziness. Okay, so we don't need to go over, we're just going to look at the third and fourth elements because those are the ones that are different. Okay, to prove the third element, the Commonwealth must prove beyond a reasonable doubt that at the time of the operation, the percent of the defendant's breath was 0.08 or greater. And then again, they can look at the test, right? So whether the test was administered within a reasonable amount of time of operation of the motor vehicle, whether the person was certified, the testing, right? All the shit we just heard from Dr. Fowler or whatever his name was. To prove the fourth element, the Commonwealth must prove beyond reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of another person. Person acts negligently when they fail to use due care. That is, when they act in a way that a reasonable person would not. And again, the reasonableness standard, the defendant acted negligently if they drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that they could have avoided by driving more carefully. The defendant's intent is not relevant in determining negligence. The Commonwealth is not required to prove that the defendant intended to act negligently. The issue here is whether or not the defendant drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account any evidence about, and again, a lot of this is the same, the rate of speed, time of day in the weather, and any other factors you think are relevant. And then again, cause the death of another person. And this is, I think, the same, right? The defendant's conduct was necessary to bring about the death. It wouldn't occur without the defendant's acts. And this is the same. This is the same. Yep. And again, because and probable consequence. So even though this is essentially like a drunk driving situation, it doesn't say that the person has to hit them, right? It's just that their actions could have caused it. So they could find, as per the verdict form, right? They could find just this one, or they could find, and again, you can think of this as 0.08 and negligence, right? Or they could find this one and the first one, which was reckless and irrespective of blood alcohol level. How can they prove it? Well, we just read it. A person acts negligently when they fail to use due care. That is when they act in a way that a reasonable person would not act. This can happen by either doing something that a reasonable person would not do under the circumstances or by failing to do something that a reasonable person would do. The defendant acted negligently if they drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that they could have avoided by driving more carefully. So if somebody's just like driving around at like a bazillion miles an hour running red lights, as an example, right? Just to be obvious about it, right? I think a reasonable person would say that that is not driving carefully and that it's negligent. The defendant's intent is not relevant in determining negligence, right? The issue here is whether or not the defendant drove as a reasonable person would have under the circumstances. That's the question. And that's very subjective, right? Okay. Next. And I will say, guys, I know this is a lot. It'll be worth going through this more than once because this is a lot. The next lesser included offense on here. This is all on one count, guys. Offense number 2, involuntary manslaughter. So this is the one, the wanton or reckless conduct. Okay. Unshare, reshare. Okay. Involuntary manslaughter caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that created a high degree of likelihood that substantial harm will result to another person. Wanton or reckless conduct usually involves an affirmative act. An omission or failure to act may constitute wanton or reckless conduct where the defendant has a duty to act. Proof that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct. The Commonwealth must prove the following elements beyond a reasonable doubt. 1, the defendant caused the victim's death. 2, the defendant intended the conduct that caused the victim's death. 3, the defendant's conduct was wanton or reckless. 3, the defendant did not act in proper self-defense or the proper defense. So here's the other thing. The reason why the Commonwealth is trying to prove that she hit him with the car is because they're trying to get second-degree murder. That's what this is. This is making it very clear that the collision, I think, is really only relevant as it pertains to the second-degree murder charge. And why? It's the only one that requires intent. Now, intent is required in the other one, in count 2, only as it pertains to, like, not that they have to intend the death, but that they intended the behavior that caused the death, right? So, for example, intended to drive drunk, intended to drive away, intending to drive away, right? For example. So the reason that they're trying to prove the collision is because they want that second-degree murder. That's what that is. Okay, the second element is the defendant, again, intended the conduct that caused the death. Not the death itself, but the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And actually, let me just now just double checking, rethinking it. Hold on. Let me just make sure, because this is just so confusing. Right. Yeah, I just wanted to confirm. Right. I just scrolled back to the second-degree murder, intended to kill, or intended to cause grievous bodily harm. So, for example, if she intended to run him over or hit him with her car but not kill him, I'm just saying, as if you're the Commonwealth, right? That the intent. That's why they're going for that second-degree murder charge, and that's why the collision. Yep. So that's the distinction. Intended to cause the harm. This is more directly related to causing the harm to the victim. Whereas with everything else, the intent only applies to an act that could have led to it, basically, in summary, kind of, right? Like, I mean, we've broken it down, so we're going to keep reading here. Okay. Okay. Okay, let me actually read this. So the first element is the defendant caused the death. A defendant's act is the cause of the death where the act in a natural and continuous sequence results in death and without which the death would not have occurred. A continuous sequence. That allows for other things to occur after the defendant's involvement, right? The second element is that the defendant intended the conduct that caused the death. Not intended the death, intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. Yeah, keep reading, Chelsea. The third element is the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct that involving a grave risk of harm to another person that a person undertakes with indifference to or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by his conduct, his subsequent acts amount to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant himself did not realize the risk of grave danger or grave harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. What I'm getting from these jury instructions, they're literally written so that you get a conviction. Like, this is crazy. I've read a lot of jury instructions in different states. These are incredibly incredible in so many ways. They're so convoluted. They're so subjective. And it's like finding a way, no matter what, to where you can convict. It's just crazy. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonable, careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. And then again with the alcohol. Failure to act, that's not what they're going for here. That's not what they're going for. They're not doing the duty of care thing. So I think we're done with this document for now. Okay, so now we go back to the thing. Okay, we're making our way. We're making our way. Okay. So now so now we are done with up to number 3. Manslaughter. Motor vehicle homicide. Hang on. Oh, that's the ones we already read. Where's the I swear to God. Did I not have that pulled up? Hang on, let me check my file thingies. Do I not have? Oh, I don't have this one pulled up. God, I have so many. I don't know what's wrong in Massachusetts. I guess a lot is wrong. Because the way that, anyway, motor vehicle homicide. How are these the same? Okay, fucking hell. I can't find, I might have to come back to this because I don't know where I have that saved. Jesus Christ. We're going to have to come back to it because I can't find the manslaughter. Okay. Well, obviously I wasn't kidding, right? Though, like that, I've just confused myself into oblivion because it'd be so much easier if on here they listed the actual numbers for the charges because they make this impossible. I'll just be honest. Like, it's just crazy. The work. Y'all have no idea what it takes to get the jury instructions for this stuff. I'll just tell you guys right now. It's a lot has gone into me trying to obtain all of these. And even when you do, it's so convoluted because of the way that they're labeled. It's just crazy. We're going to come back to this. And then there's count 3. Jesus. So we've gotten through some of this, but not all of it. We're going to table this because I don't know where I have this other document saved. And I just want to make sure that we don't just skip over something. And so I'm going to have to just go back through, and it's just very confusing. The way that these are existing. But I hope that what you guys have seen thus far is how the languaging allows for them to find her guilty of certain things, even if she didn't hit him. And not that that's a good thing, right? But just that that's what it is what it is. Those are the Massachusetts jury instructions, right? And that you can see why the Commonwealth is harping on the weather and it being dark. And you can also see why potentially the defense is really wanting to prove that he wasn't on the lawn that whole time, you know, that maybe he went in the house. The but for. It's the but for. Because again, that's even apart from a collision. So hopefully that makes sense. I'm probably just confused the fuck out of you guys, but we will continue to talk about this. And are you singing a song, Twiz? That's from that song, right? Anyway, okay. I'm sure you guys have probably all glazed over it. I don't blame you. This is dense. Imagine being on the jury. I mean, when you get to this that we're talking about, it's just so complicated and convoluted and a lot. So, okay, we're going to go ahead and redirect though into the Nick Balance testimony. So, okay, so let me go ahead and roll the outro. But thanks guys for being here. I'll see y'all here in a second. Love y'all. And here's the outro.